Right. Yes.
Niranjan Mar.
Yes.
Item number 2, Lordship, supplementary list. Item number 2, but the petitioner will have a
Uh-huh.
highly additional affidavit, some documents, Lordship. That is the only 2 weeks after maybe.
What is this matter is about?
Matter is the discharge against revision.
You are a
against
discharge
revision-
application. You are
revision against discharge.
Your
I have-
discharge application is rejected or what?
Discharge petition with
So what additional document will file?
additional document is that relating to the case, mutation case and.
Obviously, you file additional document relating to the case only.
The documents are the vigilance department and charge sheet documents. That the document and charge sheet document. Charge sheet document.
So see, the matter was listed on 26
Only
on
20.
20th June 2024. You short time. And again,
Petition at all. Yes, then
Only-
mother of the petitioner was a,
uh,
admission.
Miss
fee.
AKD, letter counsel for the petitioner for the second time seeking accommodation for a week to file certain documents. In the interest of justice, adjourned to next put a week scheduling review, and thereafter you just write it is made clear that no further adjournments are needed.
I to request my lord, friend, my lords, to supply a copy.
Yes,
Supply the
in the
copy.
meantime,
In the meantime, she would supply the copy of the petition to Mr. Das, the standing counsel.
No.
Yes.
I may be pardoned. Item 1, 12 and 13. I'm just praying for after lunch on behalf of Mr. Panda. He's on difficulty today.
It will be
After-
passed over. It will be
My lords,
Yes.
only passed over in item 13. Pursuant to my lord's direction, I filed an IA. Let that IA be called also
Okay.
today.
Sure, what, well,
1, 12 and 13.
Pass over. No.
Pass.
Lord, I
Yes.
beg pardon, my lord. One criminal appeal. I have filed an application for expeditious disposal, my lord. I have,
Uh,
I have given
application for
for expeditious disposal of the
which
appeal.
year appeal?
My lord, it is of the year 2019.
What
But
is the urgency?
urgency, my lord, the petitioner who is working as a teacher, being, he has been
You
deprived of
keep,
his service.
Include it in the weekly use. Get ready. We'll hear.
My lordship, item number 14 from supplementary list on behalf of Mr. Sambit Sammal. It is a transfer brief, so he is not available today. So kindly,
No, this is 2012. Let it come. We'll see
okay, my
what
lord.
can be done. Yes. If anything survives or not. Yes. Call. Any mentioning in VC? No. Proceed.
7 minutes withdraw.
Huh?
Item 7 withdraw.
Item 7. Withdraw. Dispose of it. Yes. Next. Item 3.
Bail matter.
Urgent to next week.
Item
Bail
4.
bail matter also,
May I please, Your
somebody don't.
My lord, this is a motivation of order. May I kindly extend the time.
What is the modification you are seeking?
The date has been elapsed, but the.
You ask for extension, not.
Yes, my
modification.
lord,
Extension.
extension
For the reason,
reason.
for the reasons stated in the application for extension of time to surrender appear before the court below is extended up to how much?
2 weeks.
Up to 20th of July. The petitioner is directed to appear surrender before the court below on or before the 20th July 2024 and seek appropriate remedy available to him under law. July. Yes.
Item 4.
Item 4 I extend the file.
4 only it is over here. Now 5.
Item 5.
Yes. What was this matter?
Draft case.
There is a bereavement in the family.
Draft
last time.
case.
Yes. What do you want? 5.
That it will listed in the
Weekly.
hearings
Weekly. Weekly. Yes.
and in the learned counsel. So,
Yes.
item 6.
Six. HCR has come. We'll put it in the weekly. Weekly.
So that why hearing so that matter will dispose of. Nothing matter man.
Huh? I know that we will hear it. I put it in the weekly list. Get ready.
Yes, my lord. We are ready, my lord. And their fees we will be ready, my lord.
It is in the weekly list. In the afternoon, I am waiting and calling people. Nobody is coming forward. You come. And nobody is there. We'll pick up your file.
Mr. Marana, perhaps will be busy in number two.
Okay, put it in the weekly list. Get ready and come.
Yes, yes, my lord. Okay. Well, I think that is not necessary for book. So that if my learner senior is ready to, it is not necessary for paper book. So that it.
Everybody is ready. You be ready.
Yes,
No problem.
Supply the copies which are available with you.
Now, whatever papers,
To Mr. Marana.
whatever papers you have, please supply.
Apply to Mr. Marana.
Also, LCR will come. We are.
LCR is already there. You take from.
Yes, yes. Well, so the next one we take also.
Get ready.
Yes, sir.
Don't ask for adjournment.
Deep knowledge.
Item 7.
Weekly. 7.
Withdraw. Item 7.
You withdrawal.
Now withdraw.
Withdraw. Yes.
Item 8. May I please, madam? May I please, madam?
Case of, I have filed in this case, I filed a IF for stay of operational conviction. My learned senior took time for filing the application.
I was to file.
Weekly.
I
Yes.
was to file objection, my lord. He has already been dismissed from service.
I am not interested in service. I am interested in criminal case.
In the meantime, so
Whatever.
let it be listed
Weekly.
in the hearing, weekly hearing list.
Weekly. Yes.
Along with another matter, my lord.
Give the number.
My lord, this matter cannot be listed in the weekly hearing list because your lordship may kindly have a glance to judgment page 3.
Why?
Your lordship will be satisfied. Another co-accused is absconding on the same day of judgment. The judgment was to be passed against 3.
Let it take its own course. We will hear it. Let it be in the weekly list. We'll see when it comes.
No, I am to satisfy your lordship that.
I know one of the co-accused who has been convicted. He
But,
didn't appear, so
second
therefore
one,
absconding. It's all right, but it doesn't mean that his appeal will not be heard.
Your lordship is pleased.
Obviously, if he goes somewhere and his appeal will be heard weekly. Put it in the weekly whenever it comes. We'll see.
Item 9.
9.
apply करिए कॉपी તમે hearing पे ready हो
Request.
તમારો 9 નંબર 6 નંબર આઈટમ તમે આસુનો તમારો એ નંબર આઈટમ આસુનો
BP Rao. BB Rao. It is 2000. What is this matter is about? It is listed many times.
મિતના
Is a private matter.
Revision.
State is not a party.
Eh?
Private party. State is not a party, so copy was not sought.
1 minute. I'll just dismiss it. What is it?
આઈટમ હશે
Item 9.
9
138 NI8. देखो ये तो one minute. This revision petition has been pending since 2011. 2011. Where the matter was taken up for hearing on 26/11/2011, 13/12/2021, 6/1/2022, 24/1/2024, 31/1/2022, 11/2/2022, 24/2/2024, 22, 7/3/2022, 21/3/2022, 4/4/2022, 18/4/2022, 2/6/2022. None appeared for either of the either of the parties. Thereafter, the matter again listed for 8 times. Although the parties appear, but on request the matter got adjourned. Today, when the matter is called up, none appears. In view of the manner in which the present revision petition is prosecuted, it deserves to be dismissed for non-prosecution. Accordingly, the same is dismissed. Yes.
Then item 9, my lord.
You are for?
I'm for the petition, my lord.
I have dismissed it.
No, my lord,
20 times the matter was.
yes, my lord. Now the opposite party also dead. He also, father also both are dead, my lord. If I deposit that amount, my lord, it will be kept in the court. So no will get the
During
money.
the course of the day?
Yes, yes, my lord.
What is the check amount?
35,000, my lord.
All right.
Yes.
At this stage, Mr. Rautrai appears and submits that he would be depositing the
Check amount.
during the course of the day
Yes,
before
ma'am.
this court.
Yes,
Before this court. If such amount is deposited, the same shall be put in the invested in interest bearing deposit, fixed deposit.
But in the name of, my lord, the
In fixed deposit, registrar person, and
Okay.
when whoever comes, take. With this, accordingly, the petition is. He has died.
yes, yes, my lord.
And he also submits.
The opposite
He
party,
also submits
opposite
that,
party, my lord,
the sole opposite party
Alok,
in the present case has already
Dead,
expired.
expired.
In view of the same, the petition is disposed of. Yes, you deposit.
my lord, I will deposit here, my lord, before the court below. Court below it will be.
Deposit here, because the petition was pending. Court below you want?
Yes,
to
yes, my lord.
deposit before court below.
Before the SDGM, my lord,
SDGM.
SDGM Pankos, my lord. In 1CC case number,
In
in 1CC case number 324 of 2005.
324. By tomorrow.
By tomorrow.
By
Yes,
tomorrow.
by tomorrow.
Yes.
Delay is there, my lord. So,
Delay conduct.
yes, my lord.
Yes.
My lord, published.
Next. What happened in this matter? SP Pradhan? Did you see service is complete? Mr. Pradhan was appearing, he has withdrawn. Thereafter, notice was issued. This is regarding what?
325, Lordship.
Hmm?
325.
This is regarding against the conviction of what?
Yes, Lordship.
325, what conviction you are talking about? Sentence?
Sentence 2 years, Lordship. Years 500.
They were acquitted, thereafter the state filed the appeal, revision.
Criminal Review 810, 2013 notes.
Hmm?
Criminal Revision 810, 2013.
I am not asking number. I am asking what is this matter is about. Have you read it?
Yes.
What happened?
Both the court it has been confirming judgment.
No. Not read.
For that only I was saying that you has pulled me to apply. 810. State file
I expected at least the, if the petitioners are not there, the state council should assist so that we can dispose of the matters.
Non appears for the petition on 23rd April 2024, let's see.
Hmm?
Non appears which petition.
Yes. See. Hmm?
Report notice regarding service.
23rd 4 2024, my lord.
No, the see, one lawyer was appearing, he withdrew himself. Thereafter, notice was issued to the petitioner.
Supplementary.
Service not.
Item 10, my lord.
Awaiting service.
10.
we'll do it.
Awaiting
Awaiting
service,
service.
my lord.
Awaiting service next week. Roko. Yes. Appoint someone and yes.
10 pra.
11.
Withdraw कर दिला.
Very old matters.
11.
Yes.
In this case, your lordship,
Yes, Mr.
the
Mohan.
paper book has not been supplied to me, your lordship. Last, on 10/7/2024.
Paperwork not supplied.
I added the registry, the paper book.
Why? Huh?
Only LCR is present. Paper book not. Paper is not there.
It is a copy of the petition as well as judgment copy.
At least the petition copy, at least, why don't you give? If the paperwork is not there.
I could have separated the
And then,
in section they have not.
These papers are also paperwork. It doesn't mean that the other set is only paperwork.
In section they are referring to a separate paper, that's why I problem. Here I can supply.
You supply the copy. I'll put it next week.
okay.
At least he will prepare
Along
and
with the
will
judgment
dispose
copy.
it. Yes. And you take the whatever paper you have and assist it. Maybe a case of the offense under yes.
Then let me go through the paper if let it be.
Hey, what the offense is under which provision? Convicted under
406.
406.
Yes.
406. 2 SRI. Give the paperwork. Huh? Put it next. Yes.
Item 14,
Lordship, next week, let's.
What happened 22?
12 and 13, Mr. Konda will pass over.
Yes.
Item 14, my lord.
Yes.
14 is that yesterday's matters, Lordship, have seen that the person on the basis of concorded documents from Ranchi universities got his science teacher job notes, and thereafter it is
Yes.
honored, and the officers from the Ranchi universities came and disposed
You
as
have shown me
PW7.
one paragraph of the
Yes,
judgment.
Lord, that is a paragraph 14, Lords,
14.
of the appellate court orders.
Yes, madam.
My lordship, we have got the file and brief before 3 to 4 days. So may some time be granted
No,
to
no, no.
us.
Time I will not give. There is nothing in this matter.
My lordship,
Nothing
my
in this
senior
matter.
is not.
Who appeared yesterday?
No, but not.
I'll keep it on Monday. You get ready. Maximum Monday. You
Okay,
don't
my
have papers, and take the papers because I am going to dispose it up.
Okay, my
See,
lord.
I'll tell you what had happened. You have obtained a job by producing some fake document, and fake
BSCBT.
document PW7. The witness, he has deposed that the certificates are fake, and it was verified from the Ranchi University. Ranchi University also says that the documents were fake.
Oh, my
So
lord.
therefore, as it is, you lost the job. Now you are convicted. So we are proposing that you will not be sent to jail, and we will give the benefit of probation of 400 and close it.
Okay, my lord.
So convey it to your senior
Monday we will appear.
Monday. Monday, convey your senior so that the supplementary.
Senior or second also.
See, you can also read it. Take the file and read it.
Okay, my lord.
That is the best
Oblige.
thing you can help to your client. Read it.
Oblige, my lord.
Yes.
15. My lord, this is 138. 138 NI matter. Last occasion, my lord, grant us time for any scope for settlement or not.
That was the peremptory order. Your lordship may kindly
Yes,
see.
yes.
I pray for
I'm on
Passover.
that.
My learned is on his legs. I pray for Passover. My learned is on his legs. He will conduct this matter.
But no question of adjournment
My
thereafter.
lord, my
I'll
lord.
tell you.
My lord.
Peremptory order was
My
passed
lord.
last time.
Much
Either
ob-
you settle or I'll dismiss.
My lord.
16.
16.
What is this matter?
Against an ordered rejected discharge application. First matters 26/14.
Discharge application were rejected.
Reject, thereafter they come up.
Rejected in 2014.
In the meantime, my lords, the date was been fixed for framing of charge, my lord. I think they have moved application for adjournments.
Yes, the matter is pending since 2014.
Yes, case was posted to 9 January 2014
Charge
for
has not been
framing,
framed.
for framing of charge.
You're taking adjournment
Yes,
No,
yes.
no.
since the 10 years.
Yes, sir.
Yes,
Get ready. I'll dispose it up today.
3 items. lordship.
Get ready because 2014 your discharge application was rejected.
And case was posted
And
to 9
this matter is
1/14
pending since then.
for
And you
framing
are
of
seeking
charge.
adjournment since last 10 years. 10 years.
Yes.
Get ready. I'm passing it over. Don't see the papers here. Yes, Mr. Mishra, the earlier matter, what do you suggest?
But here your lordship wanted, but that the petitioner come with a draft of 70,000 for settlement, my lord, 138 method. My lord, I am only praying for my friend is there for Tuesday because she was, my lord, unfortunately, I called him, he didn't receive my call. When today morning he
I'll
received,
dismiss it, then he'll come.
I'll just tell your lordship the what happened. He said I was in a puja, I was not receiving your call, and today morning he said I said you will be inside, but you don't accept a proposal of the.
What I'll do is I'll dismiss it.
मंगलवार को खाली
and
रहिले
open application for restoration along with the draft. I'll restore it and
खाली मंगलवार रहिले तो ମୁଁ draft ଦାଖଲ କରିଦେବି ଆଉ ତାକୁ କହିଛି ରବିବାର ନ ଧରିକି ଆସିବାକୁ.
shall I record it?
Yes, my
Right
lord.
on.
And if
Mr.
it doesn't come, he will
Mr.
suffer, my lord.
Mr. Mishra,
Today morning he has given a statement
petitioner
on instruction, your
submits
lordship.
that on
message.
instruction
Ma'am.
submits that his client was not available to prepare, and he was not available. Therefore, he seeks 2 days adjournment so as to enable his client to prepare the draft of the check amount.
70,000 ଆପଣଙ୍କ ଚେକ୍ ହଉଛି 63 ଆପଣ କହିଥିଲେ 70,000 ଆଣିବା ପାଇଁ.
Draft of rupees 70,000.
Right.
70,000. 70,000. Release the matter on Tuesday, and Tuesday, so as to enable the petitioner to deposit the draft before this court.
Right.
So as to enable the petitioner to bring the draft on that day. That day to be disbursed to the opposite party.
ମୁଁ in the name of party କହିଛି କରିବା
In the
ପାଇଁ
name of the party. To
କାରଣ କୋର୍ଟ କ
dispose-
ନାଁରେ କହିଲେ ପୁଣି ଏଠି ଡିପୋଜିଟ୍ ହବ ଆଉ ଥରେ ନେବେ
to
ହଇରାଣ
disposed with the
Man.
to the
ମାଇ ଗ୍ରେଟଫୁଲ ମ୍ୟାନ୍
meet on Tuesday.
ଗ୍ରେଟଫୁଲ ମ୍ୟାନ୍
And it made clear that in the event the draft is not submitted on that day, the present petition will be dismissed.
ହାର୍ଡ ଅନ୍ ମେରିଟ୍ ନା ତାପରେ ଆପଣ ଡିସମିସ୍ କରିବେ କି
Will
ନାହିଁ
be dismissed, no, will be disposed of without further recommendation.
ସେଟା ହବନି ଯେତେବେଳେ one
Get
side-
it? We believe you that you will.
it has to be that way only.
And he must be trying what to do. The clients are like that. What?
ନାଇଁ ସେ ଗୋଟେ ଅଦ୍ଭୁତ ଜିନିଷ ହେଲା ସେ କହୁଛି ମୁଁ ପୂଜାରେ ଥିଲି ଫୋନ୍ ଧରୁନଥିଲି ମୁଁ ଗୋଟେ ମେସେଜ କଲି ତାକୁ ରେସ୍ପଣ୍ଡ କଲାନି ଆଜି ସକାଳେ ଫୋନଟା ଧରିଲା ବେଳକୁ କହିଲା ପୂଜା ମୁଁ କହିଲି will be inside ପୂଜାରେ ବସିଥିବେ
His client.
No, in the jail also there is facility.
My lord. So that was the genuine difficulty. I was wondering why. it's
Anyway,
not distributed.
this is the peremptory order.
No, ସେ ରବିବାର ନ ଆସିବେ ଧରିକି draft ଟା। ତେଣୁ not even I am just taking a
And
laxity of
if you are getting it on Sunday, Monday morning you mention so that I will take it and finish it up.
Sunday I am getting it because if he doesn't give me I am not going to his council also.
His client, my lord, he can afford to engage him as an advocate for, my lord, Mr. Mishra, as a senior advocate, he is happy. He can afford that.
There I
Ma'am,
can't comment.
I can your lordship knows it better and I can share that story out of the court
He might-
as a senior counsel how much I get. But that is my happiness.
Senior advocate, senior to be
And the advocate general is saying
Item 16.
our esteemed
No, state is saying.
and we respect and revere him always.
Yes, madam.
Right from our childhood.
Item 16 pass over, already written note complete, my senior will have.
Okay, pass over.
17.
మన కన్విక్షన్ ఆర్డర్స్ 379 లాస్ట్ ఆఫ్ జనరల్ సో నాన్ అప్రిషియేట్ అడ్జర్న్మెంట్
So, in the interest of none appears, huh? So,
వీక్లీ ఆమె
yeah,
ఆమె క్వశ్చన్ అప్లోడ్ చేయాలి ఓకే
I'm appointing you amicus curiae in this matter. Mr. Avat Patnaik, Avat Monty has been appointed in the copy of the table shall be supplied. Please, when? Tomorrow? Day after, sorry, Monday, Tuesday? Tuesday. Get the paperwork from the registry.
his name may be reflected
Item 18.
Lordship, on behalf of Mr. Dismissal, prefer Passover.
18.
Yes, sir.
Yes, pass over.
19.
Yes.
Offense under section 406 of IPC Lordship. And here the petitioner, as for allegation, you are the president, Lordship, a particular cooperative society. That is name and style, Lordship, that is Sri Ram Chandra Weber's Cooperative Society Limited.
Yes.
And Lordship, sir, allegation of misappropriation of Lordship, 1,16,855. The capacity of the president, the allegation, and he used to supply yarn and to the society's Lordship. And due to some reason that could not be Lordship delivered, but the other allegation says Lordship.
Yes.
And as per the allegation of the secretary, the case has been lost. And Lordship, kindly see page 9.
9.
And right page 9, Lordship, running page internal page 2 of the judgment.
Yes.
Lordship, here, Lordship, kindly see points of determination of the case, Lordship, 4, rightly. And court below has framed the Lordship points. Whether during 97-98, Lordship, allegation of 97-98.
Entrusted with.
Lordship, entrusted with yarn by the state Weber's cooperative society, but dishonestly did not deposit the same in the society and
What
thereby.
are the evidence which is come on?
Lordship, there is no, Lordship, kindly state have come on presumption. Lordship, kindly page 4, in page 11, that is internal page 4. Lordship, this-
PW 1, 2 and 3 were the members.
Lordship, 1, 2, 1 is member, 2 is member, 3 is member, Lordship.
And 5 also.
5 also member,
The
Lordship.
informal term secretary.
PW 4 is, please,
And 6 is chartered accountant.
Lordship. 6 is the chartered account. 7 is the junior clerk. He is the Lordship, the person, he has proved all documents. And PW 8 is the IO. And DW is the one of the board of members of defense witness, Lordship. And DW 2 is the also accused, Lordship, the present petitioner. Yeah, Lordship, kindly see, come to, well, perhaps these 2 paragraphs suffice to enter prove my case.
Yes. Para?
Running internal page 4, Lordship, that is para first, para second, Lordship, para.
Yes.
Para first para. 1, 2, 3, 4, 5, 6, 8, 9, 10, 11, 12, 13. From below, Lordship, 14, this Lordship, this witness. This witness, this clerk, Lordship, this witness admitted that.
PW 7.
Lordship.
This witness admitted.
That he did not prepare these bills, but he is the custodian of those bills, and further admitted that he was not present when yarn was taken by accused, and admitted that 2 bills signature of either GM or MD of the Affairs Society was not there. So, Lordship, he is not the author of the documents. He is admitting he is the mere because he is the custodian of the document. He has given the deposition, Lordship.
What the account, audit, account.
Audit says that or with presumption, because there was bills, Lordship, on presumption they are saying the must have been done. Lordship, kindly see, Lordship, kindly, another paragraph is there. If Lordship kindly, page 14, page 14. The finding of the court will be very peculiar, Lordship. Lordship, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. From top, Lordship, from 15 line, apart from the entrustment, can safely be held that the movement accused recipient and evidence of the staff of the state handloom, as well as the evidence of the chartered account, shows that the reconciliation statement, it was ascertained that accused recipient in the Lords. Further, it was argued by defense that IO did not examine staff who prepared bills in the state handloom. In the absence of that, it cannot be held that definitely that accused received the yarn. And Lordship, the next page, Lordship, kindly come. Next page.
Yes.
I'm reading the entire paragraph, Lordship, that you with state handloom regarding genuineness of the 3 bills, because they're relying upon exhibit 15,
and
16,
the entire amount within this 3 bill only.
3 bills, Lordship.
Exhibit 15, 16 and
15 and 17, Lordship. As there are exhibits of 57 was filed by the staff of state handloom, and his evidence of such bills accused has received and further genuineness of those received by 15 and 17, which were challenged on the ground that there is no seal on it. But I don't think it material edge, because state handloom, because being a government organization without any basis, would not claim that yarn has not been issued. This is my Lordship. See the contention on presumption, because the entire conviction has been made. Lastly, defense counsel argued that the books of accounts received are not conclusive evidence, and therefore accused cannot be held liable. Even in this case, oral evidence of witness specifically shows that while accused were working as the president of the cooperative society, was authorized to receive the yarn, and basing on that, he received yarn from the state handloom. From the above discussion, it is found that accused received the yarn, did not deposit the same in the cooperative society, and evidence of witnesses specifically show that accused was issued notice for depositing the yarn, which he received from the state handloom, but he did not attend any meeting nor deposit yarn. Such conduct of the accused show he entrusted with the yarn, and with the dishonest intention did not deposit such and such. This is the findings, and accordingly he is convicted of 406. If you Lordship see the order of the appellate authority, no discussion, Lordship, the entire pleadings of the Lordship, the petitioner was before the appellate court regarding entrustment, that is non-fulfilling any ingredients of 406 of IPC. A Lordship know that the preliminary 3 ingredients are required to Lordship convict under section 406 of the IPC. Lordship, so requirements is laid down under section 405 of the IPC, Lordship. If Lordship kindly see the provision, just I want to place before Lordship 405. May I read, Lordship? Lordship.
40?
405, Lordship. Phone है ना?
Yes.
Examination, इधर ही देखो. Whoever being in any manner interested with property, this basic requirement, Lordship, he must be interested with the property.
Yarn is interested to you.
No,
That's it.
that is the whole Lordship, my entire Lordship, there is no agreement, there is no paper, scrap of paper to show that Yan has been interested to him, basing upon the report of the last 3 bills, Lordship, where there is no seal and signature of any authorities, and because taking a statement of only the junior clerk who are the custodian of those documents, and Lordship, the author of the document, they have never been examined, Lordship, and on presumption, they are only believe court, London court believing,
Then
because
your case is there is no interest.
entrustment, Lordship, that
So there is no 40.
Lordship, 40, Lordship,
406.
406 is Lordship, and Lordship, if and Lordship, another 2 aspects, Lordship, I'm just may permit to read the entire offense, Lordship, or with any dominion over property, dishonestly misappropriation. This is the basic requirement of law, Lordship. So dishonestly must be proved in this document. There is no such proof. There is no iota of evidence or any line of observation by the London court below that there is dishonestly they has taken other money. Then or converts to his own use of that property, or generally uses the disposes that the property in violation of any direction or law prescribing the mode in which such trust is to be discharged, or any legal contract express or implied, which is made touching the discharge of trust, or willfully suffers any person to do commits criminal breach of trust. So there is no agreement and there is no criminal trust, and there also they have not whispered a single word regarding mens rea. In absence of mens rea, Lordship, ill intention, the offences cannot be satisfied, Lordship. And Lordship, the specific averment, sorry, Lordship.
Yes.
And if Lordship says the 406 also, the basic requirement law, the ingredients, Lordship, must be the first ingredient, Lordship, there must be entrustment of the property. Then, Lordship, they have to show my dishonesty. Then, my Lordship, my ill intention, my mens rea. And then, Lordship, the entire documents cannot be proved, enter the sequence of events on presumption. The Lordship kind of the peculiar fighting of the London court below, because the allegation, the state is the Lordship, the opposite party, and because they are relying upon the documents of the state without Lordship examining the author of the document, mere making a statement by the custodian of the document, I have been committed, Lordship. And Lordship, to that effect, Lordship, come to Lordship, page 21. The finding of the court below, Lordship. He has enlightened some things, Lordship, some Lordship about entrustment. Page 21, para 6, Lordship. Lordship, may I read the entire paragraph. Keeping in mind the, Lordship, got it?
Yes.
Keeping in mind the submissions advanced on behalf of the appellant, and there being no written objection filed by the respondent, nor any active participation in the argument, the impugned judgment is perused by the forum minutely, sorry, Lordship. Also, the LCR which was called for has been perused by this court to appreciate the evidence of the prosecution while perusing the impugned judgment with that of the allegations brought against the present appellant.
The prosecution has not done anything, still the appeal is dismissed.
Lordship.
How strong the case is against you?
Well, Lordship, this court finds that the evidence of the prosecution witness documents relied upon the London court below in asserting entrustment has been well proved and has also been accepted by the London court below, since the entrustment is main
Yes,
factor
I
in the.
understood it now. You tell me,
You
answer one thing. The allegation that from the state handloom cooperative society, yarn was handed over to him to deposit in the society. What is the material you have? That there it comes interest. It was given to him by the state handloom to be deposited in the society, and he didn't do. That's the whole gamut of
He
it.
has received with his signature. Final kind see page, internal page 13.
That's it.
Regarding entrustment, by the first. Admittedly, that PW7 who is the accountant.
Yes.
Middle portion.
Yes.
Admittedly, evidence of PW7 shows that he is the custodian of records of the state handloom and another person issues are. However, on perusal of exhibit 15, 16, and 7, these 3 documents is a matter of
It's found.
It is found that the accused signed there as the president of Sairam, Sriram Chandra Weber Cooperative
And
Society,
received the earned
and received the
on the
so
three
it is
occasions.
clearly established that the
Therefore,
accused has received the-
considering the evidence of PW and the clerk, the state handloom, it is clearly seen that the accused had received the earned,
Yes,
and therefore such argument advanced on behalf of the defense is not valid.
and if your lordship will see that from the.
Yes, sir, you have
he has
received. Entrustment is there.
Lordship, no lordship, my humble submission, that was a mere bills. And lordship kindly see that has been clarified in next page, lordship. Lordship kindly see there is no signature, lordship kindly.
Your signature appears, you
But-
identify.
Signature.
But that bills cannot be treated as a lordship entrustment. There must be a lordship kindly say relying upon the very genesis of the decision, lordship 1985 judgment, lordship
What is
kindly
the
say.
sentence?
Lordship kindly come to, lordship, just I'm relying on judgment of Honorable Apex Court. Lordship, this is a 5 judge bench, lordship, just I'm reading the judgment and then I'm, because I have a single copy, I will pass over to lordship. It is lordship 1985, 1964 lordship, 965 AR 1433 lordship. That is, just I'm reading the findings of the Honorable Apex Court, lordship. Delivered by Harish Chief Justice, lordship. He pointed out that before criminal breach of trust is established, it must be shown that the person charged has been entrusted property or with domain over property, and a partner does not in ordinary course hold property in fiduciary capacity. The Lord Chief Justice further pointed out that there is really no distinct or defined share or partner in any item belonging to the partnership. Upon dissolution of the partnership and after an account is taken, it may be turned out that a partner who retains an asset in
Yeah,
entire.
you are theoretically absolutely correct. But on facts of this case, whether the judgment.
Lordship, kindly come to lordship, the next, perhaps my
Only
lord friend.
positive thing what I found.
Lordship.
This entire this
Lordship.
case, come to page 18, come to page 16.
Lordship.
1
16. Lordship.
Hearing in the question of charge.
Lordship.
Charge means this should be sentence.
Had both the sides on the question of sentence. Consider the facts and the circumstances.
Nature of offence.
No, lordship.
I am not inclined to extend the benefit of provision.
Lordship.
This party is the only thing which found favor.
But that's true, lordship. But lordship, can you come to, because below 3 lines, the entire fact is there, lordship. Lordship, my lord friend relied upon that he had received. Lordship, I'm reading just.
I'll extend the proof benefit which was rejected by the trial court.
Lordship.
That is rejected by the trial court, I will extend.
Lordship.
Okay. Judgment is pure. Yes.
May I give the judgment, lordship? No, not
theoretically absolutely correct. But entrustment is there because PW7 and in the 3 exhibits 15, 16 and 17 your signature appears.
No, lordship, one thing, lordship.
And audit report appears at the face of record.
No, lordship, may I clarify, lordship, one thing. Lordship, kindly just want to read just below 3 lines. After completion of that sign there, lordship. Further genuineness of those received by 15, 16, 17 were challenged. Lordship, that is very important.
Challenged by you.
Yes. And the
finding is otherwise. Concurrent finding by
no, but facts are there, lordship. But facts are there, lordship, kindly. On the ground that there is no seal on it. But so lordship, there is no seal and signature. So there, that is not a genuine bill, lordship. So if lordship, kindly see, if the documents must be generated by someone, lordship, because the official document, lordship, kindly consider one aspect, lordship. It is the official document.
Show me suggestion put by you to the witness.
Lordship, that is there, lordship.
So come to the evidence.
Deposition copy kind. Deposition copy.
What have you asked to 7?
7 taking out.
PW7.
It is 7 dead. Cross examine lordship, cross examine patta.
Yes.
I deal about files regarding payment. I have given order to accused, but I have not given any cash or yen personally. The dispute relates to 97-98. Without referring file, I cannot say regarding total payment. Any person authorized by the board attend handloom office is received cloth cash during investigation. Police took resolution copy and order receipts I signed on the seizure list, which was prepared by police, and there is no transaction with Shriram Society. Let's see. I cannot say if that society had reconciliatory statement for 997, Assistant Director Textiles or his staff attest the genuine resolution. It is not a fact accused never received the yen cash virtue by the resolution. So that suggestion is there, Lordship. And he admits himself. There is no seal and signature, nothing.
And question number 5, just see.
Lordship.
Read question.
5, Lordship.
Question 5. PW7, question 5.
Question number 5 तो नहीं है। और 4 sorry
He suffered complete extensive cross-examination. You could not elucidate a single thing.
मो पाखे नहीं सिर्फ 4 तो नहीं एग्जाम
Is there with me.
तो देखि दी मो का नहीं मोर 3 सरी जाउची सरी जाउची
He suffered very extensive cross-examination, but nothing.
Your Lordship saying OP number 7, the period 7, Lordship.
It's not a fact that
Ramsunpur Sundara Lordship.
Satyavadi Padi, the 3 false bills are created. This is the only suggestion you have asked. Nothing else.
Lordship, this is perhaps wrong file line. This is more than more chari question. Lordship, I have to copy.
So this is evidence is there. LCR is there. I am reading from the LCR only. Handwritten cross-examination and PW7.
I have the type copy.
Question number 5, this cross-examination question number 5, just read.
मो पाखे 5 टाइम 4
Parawise is there.
4 सरी
5, 6.
Can you verify the record, Lordship? Perhaps
Verify if you want to add, but
नहीं by chance wrong कर दी upload कर दी थी बे
no, handwritten. There is no question of your record might be wrong, but this is can't be because it's handwritten. Judge is signing here.
But I have the copy, but question number 4
this is not typed one, this is handwritten one. You might have typed it. This is handwritten one here.
137, GR 137.
Handwritten. If you want to see in the record, if you can. But I will grant the benefit of probation of offenders to which has been rejected by the trial court by maintaining conviction. Yes. Next. Item 20.
Note to them, Lordship.
Very good. Give.
Supreme Court judgment.
And along with the judgment.
Judgments, Lordship.
And highlight the judgment.
Highlight.
Don't give.
Lordship. Grateful, Lordship.
Very good. Thank you. Judgment result.
Lordship.
Karma IPO, Mr. Dalai, learned counsel for the petitioner submits that he would file a short submission after verifying the trial court LCR, after verifying the along with the relied upon judgment. They may be within two days.
2 days by Monday.
By Monday. Yes.
Lordship, may permit to see the records here.
Yes, yes, it is permitted. You can see, yes.
Offense alleged against the petitioner.
Yes.
Perhaps High Court will provide the pen drive.
Pen drive you bring and take it, no problem.
Lordship, grateful, Lordship.
This is a standing instruction. Anytime you can take the LCR, no problem.
Lordship, grateful, Lordship.
Yes.
My lord. Offense alleged against the petitioner under section
item 21.
20.
Yes.
Offense alleged against the petitioner under section 376 and I am convicted or arraigned for 7 years and pay fine by the court, learned court of the additional session judge, assistant session judge, and additional session judge. Against this order, my lord, I have challenged in this revision picture. The prosecution story reveals that on 28 2006.
I will prepare a written note.
Written note, I will prepare, my lord, and I have also citing one decision which is totally squarely covered to my case.
Oh, you
only on basis of evidence of the prosecution.
That's enough. proceedings
Not
made.
enough, my
Yes.
lord, that has been already discussed in another.
The quality of prosecution, prosecutory evidence has to be seen. If contradictory and all, then give the written, you have written submission.
I'll file the written.
You file it up weekly. Prepare, counsel for the petitioner submits that he would prepare he will file a written submission not exceeding 10 pages along with the relied upon judgment. With the matter in the weekly from next week. Get ready and come.
My lord, that date, my lord,
Monday, Tuesday.
my lord, next week I will not be available.
It is in the weekly
August,
list.
my lord.
Next week, weekly list. You come anytime.
My lord, in August I will be.
No, it will be there. Whenever you come, I'll clear it. Don't worry. Whenever you come, no problem. Yes. 2014 matter, we will finish it up. Yes. 21.
21.
Yes.
Yeah, please, ma'am.
Yes.
My lord, on the last occasion, this is a revision filed by the victim in this case, that the accused persons in this case, although the appellate court had confirmed the sentence passed by the trial court, the appellate court released them on probation act, PO act. They were released on PO act.
Which I have been doing every day.
He has challenged that.
We have challenged
Why
that
he has
one.
released
The release of the accused on PO act.
What is the offense?
Offense under there were
341, 323, 324.
24 and 34 IPC.
Convicted in 2008.
My lord.
At that time.
Today we are offense is for 2000. 2002.
2002.
Leave it here, unnecessary.
On the last occasion, my lord had instructed them to take instructions from the client.
Compensation, little compensation.
Compensation, regarding compensation.
Compensation.
323,
Fine.
you have beaten them. Enjoying the probation.
How
Pay
can,
some.
Lordship, how can compensation?
Eh?
Lordship, they
Don't show me books and this thing. Don't give me judgment.
PO act.
You have been given the PO benefit. He is challenging it.
Yes.
Therefore, I suggested that since it is a case up to 323, you have beaten them. Pay.
Lordship, the evidence of the medical officer, that is simple injury is simple in nature.
That is why 323.
323.
Then-
Lordship, the Supreme Court decision is there.
But
Lordship,
even
the
if
PO
we-
act is the length, petitioner is the.
Am I saying
accused
anything?
person. Is
No.
the-
You are entitled, but since he has challenged, you pay the cost of the prosecution, what he is doing.
My lord, they have
What
not also
person-
challenged the judgment. They have not come under.
That has
in
become
appeal.
final. That has
It has become final.
Conviction has become final. You are not challenging the acquittal. There is no acquittal.
Conviction
No,
is
this-
Conviction is
accused the conviction.
We are not challenging the conviction.
You are.
only sentence what? Sentence.
They are the poor persons, Lordship. They have no.
Not poor persons.
How do I know? Can we?
As far as my instructions are, they're not poor persons.
Otherwise, also they are entitled for probation because the incident has taken place 2002.
2003, Lordship, 2002.
And see, that time in the year 2003, first petitioner was 57 years and second
Yes, sir.
petitioner was
On that
7
ground only
years.
they were
That
given the
ground-
benefit of
very
PO.
old.
But
So
besides the fact that they were released on
Yes.
Probation of Offenders Act, we have also challenged this conviction for not convicting them under Section 307. They've been convicted under 341, 320, 34. We have challenged that the charge of Section 307 has been not taken into consideration by the trial court. On that basis, I've also taken some judgments of the
No,
Supreme
no.
Court. What?
trial court convicted under 323.
My lord.
Have you filed before the session judge? You have not filed anything.
We have filed an appeal before, they had filed an
Yeah,
appeal
I-
before
I
the
have
You
session.
have not challenged that.
No,
No.
no. We have not.
And now appellate court order you are challenging in the revision.
One of the grounds. my
You
lord.
skip one forum.
One of the grounds.
So therefore, that ground is gone. Now I was thinking of persuading them to pay some fine or something.
Well,
If
that
they are
is
not
not-
agreeing, then I dismiss it.
No, no, my lord. That is,
Huh?
we are ready to take fine.
If they give it, If they don't give what to do, on merit they are entitled for probation. I wanted to persuade them. What was the fine amount?
Around 5,000.
5,000.
No.
I think when he released on PO.
When he released on
No.
PO Act,
Try
did
to
the
put
5,000.
fine any fine amount.
Fix it with that condition, nahi hai. Condition में fine nahi.
No fine.
No.
No finance.
Fine.
Simple imprisonment for 1 month, rigorous imprisonment for 1 year, and rigorous imprisonment for 3 years to run
No,
company.
that period is probation period is also gone. Probation period is also gone. They
Automatic.
suffer probation.
Yes.
I can't recall it.
This is their
Right.
direct decision, Supreme Court decision.
Probation period is gone now. You can't recall it.
Length of the time. Yes.
So that's what I was simply dismissed. Simply dismissed. There is no merit. This is matter so dismissed. टिक्के लिखे दो वो तो दे दो टिक्के लिखे दो
22.
Yes.
May I please, your lordship?
Let's item
Yes.
item 22
He has been appointed as a MAQ.
and 22 minutes. Acha, acha.
Yes.
No,
I thought CSA for that release matters.
No,
My lord, that is I am not the amicus curiae. This matter it was wrongly
No, it is.
in 34. I am the amicus curiae. I don't have the power in this case also.
No, item 22 minutes is that
No.
Release
But
matter.
the last order says that you have been appointed as a MAQ.
Since my power that for that is also appointed. Right.
Okay.
Right.
Millards,
What is this matter?
My lord.
Millards,
Can it be heard?
Madam, so for item 22, I miss that particular case. Will it come after lunch or Monday, Millards? So for other two matters, I'm ready, Millards.
Your lordship last order. that
Yes,
is- your
no,
lordship,
no,
I
so,
think-
like, see my list. That particular case is printed.
There is some problem. Let it be after lunch.
My-
Passover? For Monday, Tuesday.
Monday,
Monday.
23, 24, I'm ready with the instruction.
Tuesday.
Yes, obliged.
At the request of Mr.
Thank you.
24,
My
20,
22, madam.
23.
No, 23, 24, I'm ready with the instruction. My learned friend, Mr. Kunte is aware.
Yes, what is the instruction?
This is also that for a 57 application.
Amount, usually seized by the utility is the petition, the brother of the accused.
If lordship permits me, Lord, may I submit, my lord, so
Yes.
that it will be easier,
Yes.
Lord. My lord, item 23, my lord, is the brother of the principal accused who was involved in a trap case, subsequently day case, my lords. And the item number 24 is the wife of the principal accused. So both are correlated, my lords. I've got the instruction, both the matter. Let me start with the positive instruction I received. I
Yes.
pursue the matters.
Hmm.
Lord, should take out this item 24 first.
20.
The wife of the principal accused, my lords.
24, yes. Yes.
Kabu. Millards, 24, before I place that instruction, Lords, we kindly peruse that page 4, Millards. Page 4 of your Lordship brief, that will be clear, Millards.
Page 4 of
Of the petition, Millards. Page 4, paragraph 4, Millards. Got, Millards? Millards, Lords, you can the middle portion,
Husband.
there are 4 accounts, Millards. The first 2 accounts pertains to loan accounts, and the second one is current accounts, another is savings account. So his grievance paid with these 4 accounts.
First two accounts are current accounts.
But no, first as a loan account number,
Okay.
then second is loan account numbers. The third one is current accounts. The last one is saving accounts. Now her grievance paid with these 4 accounts, my lords. I have come up with an instruction. Lordship, kindly permit to place this para 2, my lords. Lordship, skip the first one. The para 2, it says verification of office records disclose that the petitioner Srimati Vidyasya Parida is filing IT returns showing her income from business of Mrs. Parida. Infra Solution, this is running a company, something like that, she claims. Trading in seasonable items. But during house search, no documents relating to the business could be found. During investigation, several.
Last line, however, the IO has
Yes,
intimated that.
so far, both the loan accounts is concerned, my lords. In South Bank, in favor of the petitioner, my lords, you may pass the orders that the petitioner.
You are talking about
2 loans accounts, my lord, he let him operate, my lords.
No, 2. However, loan account number so and so and so and so.
Pertaining to the loan accounts. These first 2 accounts, the 2 loan accounts.
And current account number.
So far, the current accounts and the savings have concerned. My submission is, my lord, lords, you may records my submission that both the accounts may petitioner be allowed to operate both the accounts, keeping intact the amount at the time of house search, my lords. The amount which was there in that particular 2 accounts, savings and current accounts, at the time of house search be kept undisturbed. Otherwise,
amount that is maintained on the day.
On the day of the house search. The amount available in both the accounts on the date of house search remain undisturbed and let the petitioner operates both the accounts.
The date of
house search, Lords.
House search. Shall
remain undisturbed. And petitioner to operate both the accounts, Lords. And so far the loan accounts, earlier 2 accounts, let them operate fully, Lords. For that, Lordship, pass the order referring to para 4 of the petition. That will be clear, Lords.
As regards the release of 3,50,000 rupees.
That is the second case. I'll come subsequently. Lordship may dispose this first case more. So that pertains to the brother case. The earlier one item noted. I'll place subsequently.
My lord,
He says that 2 loan account release.
Yes.
And current account and savings account will be.
You will operate.
You will keep on operating.
Only one.
But on the date of the
house search,
whatever the amount was there, to that extent,
because he may put me in the question. What is the reason? The reason is not the same may not as the assets that both the accounts
counted for
as the asset side of the petition.
Petition is running one company. And that is the transaction made.
No, it's absolutely false.
2 accounts.
Nothing was there.
2 accounts, my lord. There is no nexus with regard to the husband account.
That is to be established.
Because present petitioner is a income tax assess filing return is being filed and the GST is also filed, my lord, in respect of the 2 accounts.
What was the amount on the day the house search was made?
With regard to 2 accounts, my lord.
You can operate. Not touching that amount.
Because we dispute the business is nothing was
my lord. One account, my lord, it was 27,249. Another account 1,17,000.
So let me say that you are running a business, 27,000.
And that is taken towards their assets. You should be happy. You should have cooperate.
Second item.
The second one, I'll dispose the first one.
First one, okay.
Should I go to the second one?
Yes, second one.
Yes, not.
That is item 20.
23. In item 23, Lordship may turn to para 2, Lords.
23. Para 2.
Paragraph 2, Lords, or page 3, Lords.
Yes.
In fact, in para 2, Lords, you mentioned that so and so, and that para 3 is the important words. And then the para 4, Lords, contains the main grievance.
3,50,000.
Lords, para 4 says that in South the Village Department research 3,50,000 for the house. On that score, Lords, I've got that instruction. Whatever. Yes. Lordship, permit to place the second portion with regard to this first case. As regard release of rupees 3,50,000, which was seized during the house search in connection with vigilance previous case number 10/2023 in favor of the petitioner, say Kanuchan Parida, the brother of the accused, say Bhairabandhu Parida. It is to intimate that during the investigation, the IO received a petition from Sri Kanuchan Parida in which he had enclosed agreements dated 19/4/2021 and 15/4/2023 regarding receipt of rupees 7 lakhs, 3 lakhs plus 3 lakhs plus 1 lakh. The IO during investigation found that there is no mention in the
made a
fictitious
Agreement to sell.
agreement to sell, but you have purchased the stamp paper on the same day.
Concocted,
You have concocted, it appears to be.
No, my lord.
Sorry.
That's what it says.
It is there, my lord.
Sorry.
The name of the stamp vendor. See, during investigation, it is found that there is no mention of the date of the purchase of stamp paper, name of the stamp vendor used for the preparation of agreement dated 19/4/2021. Similarly, the stamp paper used for the agreement dated 15/4/2023 was purchased in 13 August 2020.
It's there.
13th August 2020 you purchased, and in 23 April 23 you are doing it.
Couldn't you leave this?
Creates a suspicion. So that
Couldn't you leave this
I
one?
have given the sell date, my lord.
No.
Not.
I'm talking about agreement. You got that 7 lakh rupees by entering into agreement to purchase, and that agreement source is this,
Yes.
and the documents, agreement documents creates a doubt. So it's a part of this thing.
My friend will leave it. This is a very
Having a
conscious.
separate base, my lord. Brother, my lord.
I'm not conducting a trial here. I can't do that. That's the problem. So both the matters, give it, I pass here. 23/20.
Sell deed is there, my lord.
See, sale deed is a subsequent thing. And
Because-
you explain the
of the
source, you explain the source, saying that this is an agreement of to the sale. And it demonstrates that the stamp paper was purchased 3 years back.
It may be purchased by
3
the.
years back. Why have you purchased and kept the stamp
For
paper?
the purpose, my lord. Thereafter they have signed.
I know these old papers are, why old papers are kept. You know
Yes.
that.
No.
And
Lots of
who
time
else
visualize.
better than you will know it?
Kuntiava knows that.
And you
He's very,
purchase bunch of old papers,
For
keep
the
it to
purpose of the
manipulate
agreement,
the
they have
document.
sell.
in fact, Kuntiava knows that. He's a very seasoned lawyer.
They may not be signed.
Stamp
but
vendor's
it is not
name?
executed.
Who is stamp vendor?
They have purchased
Where
for the
from?
purpose.
He will be in
they have
difficulties.
purchased for the purpose of the agreement. Suppose it is
Purchase
not
of
used.
creating-
Later on, after
Purchase of creating this kind of agreement to be used for the particular
that
purpose.
is apprehension.
Stamp vendor's name is not there.
The sale deed is there. I
But
have
prima-
taken my money.
See, prima facie, there is something. So it can't be, I can't pass an order releasing it.
Because you lordship kindly visualize brother of the accused, my lord. He is having separate base, my lord.
No.
And how he will be, his account will be.
Furnish bank guarantee and take it. Furnish bank guarantee and take it.
Yes, my lord.
Bank guarantee.
Yes.
You are interested in your money, why do you worry? Bank guarantee. You will furnish bank guarantee.
But
Bank guarantee and indemnity bond.
Big one.
Bank guarantee and indemnity bond and take it. Because you will put that to use. Hard case. What do you say?
I think, my lord, sir, he is depending on a certain
No,
documents.
it's, are you interested in the
No,
in the color of the note
no.
or the
I agree with
it is
you.
not the trap thing that you have to keep.
Yeah, I agree.
Number of the notes, nothing is required.
I agree with you.
He will furnish bank guarantee, your money is secured.
I agree.
It ultimately goes that you engage.
I agree with your lordship, but only thing is that he has not, so far this case is concerned, in clean hands. That is the
That's
reason.
right. I am not predicting
That's when
judgment,
that's when
judgment
no,
on
a
merit.
person who is not approaching clean hands should not be favored in any way.
Indemnity and
Yes.
okay. Indemnity bank guarantee. Allowed. Okay. Yes. 25.
Lordship, I put it to bank guarantees.
Yes, bank guarantee. I am doing.
Private party madam. Both. Kotak cooperative bank. Central cooperative bank. Opposite party.
Offense?
No, not the state, not party madam.
What is the offense by you?
Filing not.
2 years. 408, 34.
Central Cooperative Bank.
Shankar Godai.
Arise out of 1/6 case, complaint case. Forgery right, imprisonment 3 years. 3 years conviction, madam. And pay fine if it is.
And appeal? Confirm. No dismissed. Appeal stands dismissed.
Dismiss. Neither the bank nor the petitioner they have appeared.
Very strange. SI of 3 years and
Fine,
of
fine. Both parties are up.
who can be appointed as a magistrate? You come and help me.
So for bank is your concern, you have to
Forget what. See, last order was, I'll tell you, last order was, this matter was called for hearing on such and such and none appear that day. Today also none appears. It is made clear that no, if no one appears for the petitioner on the next date of hearing, the court shall proceed with the matter by appointing MI security to assist. This is the order. And nobody comes, then what to do? MI security copy this.
Copy
Okay. Tuesday?
Lordship, I will.
Tuesday. Give a copy and Tuesday. Supplementary.
Yes, Lordship. I will.
Small matters, that's not. Supply copy, yeah?
Yes.
लिख दो on the last date of hearing, the matter was date लिख दो matter was listed, none appeared, and there was a direction that if nobody appears on the next date of hearing, the court shall proceed with the matter by appointing a magistrate. Today, none appears for the petitioner, so this is also appeared. Yes.
26.
May I please, your lordship? Well, on the last occasion, your lordship had heard this matter and directed me to file a short written note of submission. I am filing it, my lord. Here, my lord, the petitioner has been convicted for the offence under section 379 of IPC.
You are ready?
My lord.
Ready?
My lord.
2 o'clock, get come. 2 o'clock.
My lord.
2 o'clock, huh? We'll hear it up.
Right.
Yes.
27.
Yes. This also you do 2 matters. One day. 2 matters, both the matters you. Same. Last time on 15/7/2024, that was listed, none appears, same order. So, both the matters one day you do.
I will do.
Yes.
28.
Lord, petitioner has convicted under 498A and 323. On the last occasion, I have told the court they have settled the matter.
Yes.
I am here, affidavit.
Yes, they've settled the matter.
No, madam.
The wife has taken 1 lakh.
498.
498. The wife has taken 1 lakh and 5,000 rupees and they are living separately since 2007.
Victim P 7 my lord, or the important P 6.
So how many accused are there here?
No, only one, my lord. Husband may prefer this revision.
The petitioner is the husband of opposite party, the informant. Was the husband or is the husband right?
Was.
So he was convicted by the trial court for alleged offence under section 498 and
323.
323.
3 years
and sentenced to undergo RI for
3 years.
3 years.
3 years and 2,000 rupees fine.
And the fine of rupees 2,000. And no, पूरा लंबा चौड़ा actually. Right now, you page.
First paragraph in revision.
File. Petitioner for an accused in PS case number 4 for alleged offence under section 4. And they put to trial for the said offence, and the trial court convicted the petitioner and passed the following sentence here. Following here. Phase 2 of the here. Phase 2 of the appellate court. Phase 2. The judgment of conviction and order of sentence passed by the court of which court passed by the assistant sessions judge Shambalpur in ST case number 339/1 of 2002 and dash 2003 was assigned by the petitioner by filing criminal appeal number 63/04 of 2005/2006 before the additional sessions judge Shambalpur. The appellate court rejected the appeal.
Appellate court acquitted to parents-in-law and only convicted the petitioner.
And rejected the appeal against the petitioner and confirmed the conviction recorded for offence under section 498 capital A and 323 IPC while acquitting him for offence under section 307 IPC. 307 IPC. Accordingly, the sentence was also modified. For conviction under section 498 capital A. Okay. 323.
307 modified to 323.
No, sentence
6 months, my lord. Sentence, my lord, 490 upper hand, my lord. 490 3 years and 5.
307 was
modified.
5 years, so that was modified to 6 years.
The sentence remained unaltered, whereas for the offence under section 323, the petitioner was sentenced to undergo 6 month RI, 6 months RI. Yeah. Next out, agreed by the judgment of conviction and order of sentence passed by the appellate court, the petitioner has filed with the revision petition. And the revision petition is pending, the petitioner he is informed, settle the dispute, But the dispute and they filed and joint affidavit with this court, which dated 17/17/24, which is taken under. Which is taken. The terms of the settlement is reflected in the affidavit, which reads as para
Compromise.
3, para 3, 4, para 3 and 4. Para 3 and 4. Since the dispute is arising out of a matrimonial dispute, and the parties have settled their dispute in view of the judgment, in view of the ratio laid down by the Supreme Court in the matter of the same case. Another judgment which I have already
BSJC. BSJC.
No. Another matter where in the matrimonial dispute, if the parties settle, even conviction can be set aside and acquitted. Mr. Dhal appear and I pronounce a judgment.
Okay.
I'll show you that. Acquitted.
Published.
Here matter compromise.
Mr. Dhal appear.
Execution case, there is mentioned that matter has been compromised at the introduction of the witness.
Oh, that I have taken out.
Judgment is.
No, I passed it. Yes, acquitted.
Conviction on 354, 6 months, my lord. Yesterday it was a lordship directed to give any judgment. I have got one judgment. 354 offense, initially it was 341 and 509 and 354.
Oh, the other offenses they have settled.
Yes.
What about this?
354 is non-reportable judgment. For that judgment,
সেটা 14.
Then?
Bharati versus State of Haryana.
What does it say? Bharati. What does it say?
That is compounded the offenses. After compromise, compounded.
That's the problem in Supreme Court. 142.
Andhra Pradesh High Court also had like that. Yesterday night I talked with Andhra Pradesh High
Show
Court.
me some High Court. The Supreme Court can do it. Who says no?
That case, my lord.
Though the allegation is under section 354, but the offense is under section 354, but the allegation is under serious.
Hello, we'll cite it and finish it up. It doesn't say 142 and all. We'll cite it and it should take them. But this is in fact exercising 142. Anyway, record it and do it. It could.
30
Lordship, RI for 1 year for 353 of IPC and RI for 1 year and 506 IPC and 3 months for 294 confirming judgment, and there are 5 witnesses examined by the prosecution, out of which 4 were official witness. Number 5 was the independent witness who has turned hostile. Allegations that while the police party trying to arrest this person in connection to another case, this accused petitioner has obstructed them, abused in filthy language, so also attempting 506.
There is a chance of acquittal.
If you will go by the merit lordship, there is no other independent witness examined except one, that is PDL 5, and he has been turned hostile. And in the DW has been examined, who is the spot witness. Before he is the owner of a hotel, and the hotel is the spot where the DW says there was no such occurrence occurred on the very date of allegation. That is the material available, and it is also borne out of records that PW3 was an accompanied witness with the consent informant was a police officer. He says in his evidence that we were with a plain dress; they were not with uniform. So these are the scenario where it is very obvious that the present petitioner was not aware that the police party has come and they are trying to arrest him. And in fact, the case is that
Conviction under section 506 and
353, RI 1 year for 353, RI 1 year for 506, 3 months for 294 of IPC.
Both the courts have.
Both they have
upheld that one. And it is also there on the, he was taken into remand in this case and thereafter
Undergone, how much?
undergone as
The
per,
substantive sentence is 2 years,
yes. No, it is 3 years, sir.
3 years. Undergone, you tell me.
Undergone exact figure is not with me, that must be there in the LCR, but
I'll take it up at 2 o'clock.
as you also, I'll go to the LCR also.
The C undergone is substantive undergone, then we will see. Yeah.
देखिए LCR देख लिया हम पढ़े. Get to.
Yeah, fast forward. Lordship, item number 31, Lordship. On behalf of Mr. Chan, Lordship, kindly pray for adjournment, Lordship.
Weekly.
Deeply.
Copy, sir. State Council copy. It is directed to supply copy. Yes. Next. 32. 2014. Yes, 32.
We have conviction under section 147, 148, 149, 326.
I'll put it in the weekly. Weekly. Okay.
My lord, sir.
Any problem?
No, no, the other 3 matters already are 2.
Let us see. Spotted. Yes. 34.
34.
How many matters are there?
I only 2. 34, 36.
34.
34, my. May I please, Your Lordship?
Yes.
My lord, here in this case, the appellant is convicted for the offense 5 clause 2 for 6 months and for the offense 409 of the IPC 6 months and for 471 1 month and 100 fine.
Undergone how much?
My lord, that record is not.
The record is there here. You
My
have
lord,
to check that record.
Bail recupe jaichi se visar ke chhe not.
It is there, must be there. If you see the proceeding and you will get it. LCR is there. See, these are the matters, short sentence, you must know how much you have undergone.
Right.
Because 2 courts have, see, we are exercising revisional jurisdiction.
Right.
The scope is very less. Okay. And if you have substantively undergone, it is 2 months, 3 months, 6 months.
This one is an appeal. This one is an appeal.
No, this is appeal. No, it's all appeal. But if the sentence is very short, undergone, then we'll convert it to undergone. Finish. Conviction maintained.
Yes.
It is only 6 months, na? Substantive sentence.
Yes,
6 months.
6 months.
See, if you have undergone 3-4 months.
I don't think so, my lord. 2-3-4 months नहीं हो पाए. उससे भी कम हो.
Maybe whatever.
Yes.
Let us see.
Yes.
Let us see. You just take it up and tell me. From trial court record just now. Wait now. Wait. At least this information should be there with you. There are many cases where the sentence is already undergone. The total sentence is already. So you must know that. Yes. 36. Yes.
I'm praying for fast forward.
Weekly list. I'll take it up with you. Because there are a couple of matters I give dictation. Please
Order of the Special Judge Vigilance Sundargarh Millards refusing to discharge him. That order is at Annexure 1, my lords.
Yes.
Lords, the FIR is at Annexure 2, my lords. The allegation against petitioner, my lords, is that in the year 2011-12, my lords, he was functioning as branch manager cum accountant of the Sundargarh Central Cooperative Bank, my lords. And during this period, what he had done was, he had issued a pay order for 6 lakhs on Oriental Bank of Commerce, Rourkela branch, and had authorized the peon, Shankar Bag, to receive the cash, which the peon did. Further allegation is that 13 pay orders worth 2,26,474 were issued, and no entries were made in the bank's book of accounts or day book, but the entire amount was credited by being debited in the adjustment register of the branch, and thereby he had misappropriated 8,26,474 rupees.
Right.
Now, after charge sheet, my lords, and supply of papers, I moved a petition for discharge. My petition for discharge is at Annexure 3. My contentions were basically threefold, my lords. Firstly, my lords, that the registers of the bank on which the prosecution relied upon, they were all computer printouts and were not accompanied by any certificate under Section 65B of the Evidence Act. So they could not have been acted upon. My second contention before the court was that the audit report could not be relied upon because an attested copy of the audit report was filed and it did not comply with the requirements of Section 63(1) of the Orissa Cooperative Societies Act 1962. My third ground for discharge was that the sanction had not been accorded by the competent authority. An objection to my petition for discharge was also filed by Annexure 4, my lords. And the basic objection was that all these were matters of trial, my lords. Now, I fail to understand, my lords, how the question of a defective sanction is a matter of trial, my lords. In my petition for discharge, I had stated that the bylaws of the bank empowers an appointment committee of 5 members who were to act as the appointment authority, and it was headed by the president of the bank. Now, this appointment committee, although it was existent, what the sanction was obtained, my lords, from the management in charge of the bank, who is not the appointing authority. And therefore, he was incompetent to grant sanction. So, this is a vital point which should have been considered. Without considering that, learned special judge, by Annexure 1, my lords, has come to the conclusion that it's not a case for discharge. If your lordship will look at the impugned order, page 21, my lords.
So let us come to the impugned order in so far as sanction part is concerned.
Yes,
Other
yes.
2 points are non-compliance of 65.
Exactly, my lords.
65 and all. Evidentiary value of the
yes, that
photocopy
is
and all,
to be
that will be
decided.
tested there in the trial.
Right, right.
That has neither here nor
My
there. Only sanction part you show me.
My lords.
If you have a case on sanction, then you succeed. Otherwise, you don't have it. Show me the sanction part, how the trial court deals with it.
That aspect has not been dealt with, my lords, at all, probably. Your lordship may look at the order at page 21. Page 22, my lords, may see.
22, huh?
Paragraph 5. No, sorry, I am placing from 21, para 3, my lords. Para 3, my lords, may see the 5th line of that paragraph.
Yes.
The sentence begins, he also submitted that the IO has obtained sanction order from the MIC of SDCC Bank. MIC will be management in charge. Sundargarh Cooperative.
Who is your appointing authority?
My appointment is the appointment committee, my lords. It's a 5-member committee.
But sanction has to be given by one person only, not 5.
The person who can penalize, my lords, that is the
Yes.
appointment committee.
Appointment committee.
Yes, as per the rules, my lords.
One member of the committee can give.
No, as per the rules, my lords, the appointment committee is the committee which can impose penalties, my lords. Rule 34 of the staff service rules authorizes penalties being imposed by the appointing authority. And the bank's bylaw in section 36 empowers the appointment committee to act as appointment authority. And that is a 5-member committee headed by the president.
Who will give sanction then?
The appointment committee, my lords.
All the 5.
If the committee issues an appointment, it's not a question of all the 5. It's the committee giving an appointment. The issuance of appointment is by the appointment committee. The penalty, my lords, that is to be imposed is by the committee. So, my lords, the sanction is to be granted by the committee. It has to be put up before the committee and then the order is to be passed.
All the members according to.
Yes.
But who is given here?
Here the management in charge, the collector was the management in charge at that time. And he has given the committee.
Yes.
Now, your lordship may see what the court writes. Paragraph 5 with page 22, the court says, at the stage of framing of charge, the court has to see if there is sufficient ground to proceed against the accused. While evaluating material, strict standard of proof is not required. And all these, my lords, have been dealt with. And then it has referred to certain judgments, my lords, and says at page 23, if your lordship will see from the bottom,
all the things are regarding the same.
my lords may see about 8 lines from the bottom. The sentence begins, standard of test and judgment, which is to be finally applied before recording a finding regarding guilt or otherwise of the accused, is not exactly to be applied at the stage of deciding a matter under 227 or 228 of the code, where the court is not to see whether there is sufficient ground for conviction of the accused or whether trial is sure to end in his conviction. Strong suspicion against accused, if matter remains in suspicion, cannot take place of proof of his guilt at the conclusion of the trial. But at the initial stage, if there is strong suspicion leading the court to think that there is ground to presume that accused has committed an offense, it's not open to the court to say that there is no sufficient ground for the offense. Now, this aspect, my lords, that the sanction was improper, he has not dealt with at all, my lords. He has referred to certain judgments. He has referred to materials, my lords. But that aspect he has not at all dealt with. And para 7, he says, in view of the authorities cited...
26, page 26, last 5.
Yes.
The district magistrate and the collector cum management.
My lords.
That is SDCC Bank.
In charge SDCC Bank Limited, Sundargarh, accorded sanction to prosecute the accused. Now, my contention that he was not the appointment authority, that has nowhere been dealt with, my lords. I don't dispute that the district magistrate cum collector has granted sanction. Yes.
Yes.
But should he not have dealt with what I have
Yes,
said?
Mr. Das. The trial court has not dealt with the sanction part.
No, in fact, he has observed, my lord. He has taken.
Observed, that is a fact. Nobody disputes that the collector has
At the end of the day, my lords.
whether he's competent or not, you satisfy me.
Yes, not. But at the end of the day, my lord, on a conspectus of all the submission put forth by my land senior Mr. Panda, my lords, the entire issues revolves around whether it's a invalid sanction or no sanction. And if I accept my learned friend's submission, my lords, his case falls within the categories of invalid sanction. Now the question is that particular concept, invalid sanction, can be raised at what stage? And if there is no sanction, that can be staged in what? That is the question of law, my lords. That has been set into rest, my lords, by a judgment of this Honorable Courts, my lord, by judgment of the Honorable Supreme Courts, my lords, way back in the 2007 Volume 1 Supreme Court, page 1, my lords.
Yes.
That says, my lords, the question as to absence can be agitated at the threshold of the trial. because that is the foundation, the ratio to everything, lords. But the question as to vexation or invalid sanction, in other words, has to be raised during trial because it requires factual adjudication. Who is competent, who is not competent, and this particular question of law.
Wrong, right, whatever you say, wrong, right, whatever. There is a sanction. The validity
And
of sanction would be
and that,
tested in the
that
trial.
involves a factual education. And this particular judgment, my lords, has been followed by the Honorable Supreme Court. Kabu. Wait, Kabu. This judgment of the Supreme Court has been followed in 2012. And your lordship may turn to paragraph 13, my lords. Paragraph 13, my lords.
Yes.
Paragraph 13, last page, lordship. I read it, my lord. In our view, having regard to the facts of the present case, now since cognizance has already been taken, in this case also, same thing happened, against the appellant by the trial judge, the High Court cannot be said to have erred in leaving the question of validity of sanction open for consideration by the trial court and giving liberty to the appellants to raise the issue concerning validity of sanctions of orders in course of trial. Such course is in accordance with the decision of this court in Prakashing Badal. Prakashing Badal is 2007, which I placed before lordship.
Yes.
Not only that, the matter never ends here, lords. Now, my lord, this particular ratio laid by the Prakashing Badal was followed in Dinesh Kumar. Now, lordship can see Gabu. The next judgment, my lords, consistently followed, my lord. Lordship can turn to page 15, para 15, my lords.
Lords, before the lordship goes to those judgments,
I'll give you the entire thing. I'll give them.
I'm not asking for the judgment.
A citation.
I'm asking my learned friend to just bear with me.
I'm deeply sorry.
My learned friend is relying upon certain citations and saying that this is a question of fact which is to be asked when at the stage of trial. Now, I will only request your lordship to kindly look at chapter 19 of the code, which deals with trial of warrant cases by magistrates and when somebody is to be discharged. My fundamental question before your lordship and the answer to be given by my learned friend is whether the court which is considering a petition for discharge before whom certain grounds are raised, can he ignore the contentions raised and pass an order without considering? Exactly. How can he pass an order without ignoring my contentions totally?
In this case,
and this is the difference between 239 and the trial of sessions cases is that in 239, my lords, he is to make examination of the accused, he is to consider the police report, documents sent under 173, and then after hearing both sides, he is either to discharge or frame charges. The difference is, my lords, that he has the power of examining the accused also, going through the records. Can he pass an order totally ignoring a contention which I have raised? My submission is that this is a fit case where it has to be sent back for reconsideration.
No.
Because he has not considered what I have raised. And what I have raised is a fundamental question of fact, which is to be decided. Now
He takes note of it, but doesn't delve upon it.
Yes.
My lords, my learned senior submission, my lords, if you accept technically, my lords, but this particular point was raised. Not only that, my learned senior's submission was also fortified by another judgment of Supreme Court, that is Nanjappa judgment. Your lordship can turn to page 22 of that impugned orders. Page 22 of the impugned orders. My lord, that has been that's been relegated, my lords. Lordship can turn to page 22. Lordship got it, no? The impugned orders.
Yes.
Page 22, that item number Nanjappa judgment, my lords. My lord, that's lends supports to my learned senior submission, my lords. That matter should be relegated, my lords.
What is the stage of the trial? Charge has been framed.
No,
my lords. Charge has not been framed, my lords.
So let him hear me and let him pass an order.
My lords, now the question is, my lords. My lord, now the question is, my lords.
What we see, I'll tell you one thing. If your discharge application is rejected, not considering the vital point which you are raising,
has to be taken out of
at the stage of framing of formal charge,
you
you can also be heard on that point.
Your lordship may see that Nanjapa's judgment. In Nanjapa's judgment also their lordships, while setting aside the order, their lordships have categorically stated that framing of charge and grant of sanction.
At the framing of, at the stage of
Yes.
framing of charge, you argue this point. I'll keep it open.
And
So far as
my
that point you can say.
And my lords also.
Your application is rejected, discharge application. Charge is yet to be framed. And you get an opportunity to argue that. You argue that point.
Yes.
Let him argue that point. How can you stop arguing? Because the trial court is unfortunately not dealt with that point at all.
In fact, that was his submission was this particular one was recorded, and he said that this
So
is.
he records the fact that the sanction is accorded by this authority.
Yes, though that is a
But
sanction.
whether the sanction is right or
this
wrong,
is
he
not a
doesn't tell.
case of no sanction. That's what the court proceeded. So this was the answer.
You are developing that. He's rightly developing that. You are developing
I go down.
In fact,
I go down, my lord.
that point,
court should have done it instead of you doing it.
that point was raised. That was the answer. Look, this is a case
this is
where
not answer.
this is not a case of the invalid sanction. It's a
But this
sanction.
will not prejudice you in the sense the prosecution is not prejudicing.
The kind,
And
sir,
this
the
is a
lordship-
valid point. Let him argue it.
Well,
Framing of
at
charge.
the stage of framing of charge.
Yes, of course.
Oh, no problem.
His application is turned down
But
without dealing with
but
that.
at the same time, my lords, my learned friends pass on this book. The section 19 of the Prevention Corruption Act, my lords, the explanation proceeds, my lords. For the purpose of the section, error includes competency of the authority to grant sanction, lords.
Let it be dealt
Exactly,
with by
let
the
him
court.
say so. In
Madam,
so many words.
The
he can
present
say.
petition is.
But your lordship will record me one submission. Lordship open that point, let him raise. I agree with you, my lords. What I suggest, my lord, lordship record my submission that petitioner's contentions regarding no invalid sanction was raised and it was dealt with, but not in a specific term, but the state.
Not dealt with.
It has not been dealt with.
The fact is recorded, not dealt with.
And the state council submitted that at the time of framing up,
Your submission I'll record.
and the plea
I'll record and the judgment.
Yes, my lords.
I'll keep it open. That point I'll keep it
No,
open.
I have given 3 judgments, my lords.
I'll record that. And if you want it back, after 4 o'clock, you will get it back.
It's
After judgment, you
my lord, it started from Pakar Singh Badal case, and it was followed by Dinesh. And my lords,
he is not disputing that.
I don't dispute.
No, only my anxiety is that it should not be recorded.
No, you tell me. He raised 2 points basically. He says that photocopy and the audit document can't be taken into consideration in view of non-furnishing of certificate under 65B and all. The veracity of this document, admissibility of those evidence will be tested in the trial. He's knocked out in there, no problem. But he raises one more point. It is invalid sanction. The trial court records that there is a sanction.
It's a case.
But whether it is invalid, it will be tested or not, it doesn't.
After recording his satisfaction, it's a yes sanction. It's a sanction has been granted. That was recorded. That was the answer. And you know that particular that costs you no more res integra. That has been said in the
I'll keep that question open. In any case, that question is always open. Is not valid, not valid.
Sir, in fact, I am constrained to make a mention that 2 o'clock matter may be taken. I am not doing well in my health. That may be taken up.
Shall I put it in?
No, Lord, I can do it because hearing was over only to produce a document.
Which item?
That is item number 33 fixed.
That MJQ matter, my lords.
That Supreme Court, my lord, that demand was passed.
My lord, he is unwell, my lordship, fixed a date. My lord, I will also come back to lordship. Another letter, your lordship wanted me to bring, my lord, despite my best. That letter was annexed in the SLP, my lord friends.
Fix it at 2 o'clock Monday.
My lord, that letter is here.
See the 2 o'clock. Why are you traveling? I will not forget. Don't
Ajay,
worry. Monday 2 o'clock.
Ajay,
Monday. He is not well.
I agree.
Monday 2 o'clock.
But that letter is here.
Monday 2 o'clock. Don't trouble yourself. Go. You take rest.
Achhi record acha, apna charge sheet acha.
You also just check it up. Monday 10 o'clock, 2 o'clock.
Entry models to control.
Entry model. Yes.
Item 11.
Yes. Please use the mic. Yes, sir.
Well, in this criminal division, petitioner being agreed with the judgment of conviction under section 406 IPC and order of the sentence
You are
passed by the
appearing
law
for the
and session.
petitioner.
Yes, my lord.
You are appearing for the petitioner.
Yes, my lord.
But since you did not appear for 2-3 hearings, I have appointed MA Keshpuri anyway. Since you are there, I can hear you. No problem. Here, tell me.
My faster some problem with the.
Anyway, tell me. This is
Under section.
against conviction.
My lord?
Against conviction.
Yes.
Then I put it in the weekly list.
Myself, Mahendra Mahapatra, I am engaged yesterday.
Hmm?
I have been engaged yesterday.
Achha.
Myself, Mahendra Kumar Mahapatra.
Okay.
Yesterday,
Then I'll put it in the weekly list. Get ready.
I'm just kidding.
Weekly list. Yes.
Well,
Next.
being aggrieved with the judgment of the conviction under
I
section.
am listing it in the weekly list. Get ready. Yes.
Well, let me. Okay, ma'am. Thank you. Thank you.
Please, your lordship. Lords, this revision was filed against an order framing charges.
Yes.
The revision was filed in 2022, my lords. Now, in the meanwhile, what has happened is that the evidence has already been recorded, matter is posted for accused. Now, the question which I had raised in this revision, my lords may kindly look at annexure 3, that is my petition, annexure 4, my lords, at page 31.
Yes.
My lords, my petition, I have stated that the present accused had filed an application for supply of documents relied upon by prosecution, but which had not been supplied. And on 11/7/14, learned special PP had supplied copies of documents available with him. Then I state at para 2, on perusal of documents and copy of relevant file number such and such, which purportedly relates to alleged commission of offence by the present accused in the making of short-term deposit with BST CCS, it reveals from the copy of the file and note sheet supplied that the file had been initiated on 26/4/2002 by the accounts officer, and the ED Finance had endorsed it to the then managing director and chairman OHRDC. This file, which has been initiated on 26/4/2002, that is much subsequent to relief of the present accused as MD ORHDC on 15/5.
These are the facts. These are the facts to be
Yes.
considered by trial
So
court.
that document, my lords, I asked for a copy of that to be shown. Now, my defense basically is that this entire file was initiated after I was relieved from ORHDC. So unless that documents are made available to me, because I am not in a position to obtain those documents. If those documents are not made available to me, I'll be prejudiced in my defense. Already, my lords, in 4 or 5 cases, I have already been convicted. And this is a case where also I'll stand convicted because of absence of papers. Lords, let those documents which are in the custody of the vigilance be supplied to me. That's all.
No. In fact, my lord, there is a judgment of the Supreme Court, my lords. The order rejecting an application of section 91 for calling for records is interlocked, it's not revisable, my lord. Now, the relief is sought for in a revision petition. My lord, I've got the judgment, my lord, I will place the judgment. Not only that, in for re-examination of witness, my lord, that for 411, my lords, is all the order passing 411 is not revisable because ultimately the lease is not disposed of.
411.
My lord, I will get that judgment. This is not; these orders are not revisable.
He says that he want to lead the defense evidence.
Any orders passed
No,
or calling for records.
He's right to lead the defense evidence.
But that's not the prayer, your my lords.
The prayer has become infructuous because of the matter has been delayed.
Cannot
But
be
these
info.
documents are vital for
Only info
I'll
orders.
dispose it up saying that a right to lead the defense evidence is reserved, you do whatever. You move application.
And I can move for those documents.
Whatever
again,
application you move, that he has a right to.
Can I, in a revision jurisdiction?
Trial court will decide it. I will simply say it has become infructuous, but right to lead defense evidence is always there.
Apart from dealing with the impugned orders, my lords, in a revision jurisdiction, my lord, what my learned friend says, I understand his predicaments. I understand his shortfalls, my lord. But the reason is, my lord, can it be directed, but is it a coordinated etude application? That's the question I put to myself.
No, I am not directing. I am keeping it open.
It is open for the petition.
For the accused to take a necessary step to lead his defense evidence. That in any case he has a right to lead the defense evidence.
My lords, please.
That you can't stop.
No, your lordship definitely.
You do whatever let him do. Where is that impugned order?
Impugned order is the order framing charge, my lord.
Page 16, my lord. Page 16, 16.
Have you taken that point in the
No.
In the trial court? What was the ground?
In the trial court, my lords, this is an order wherein charges were framed. I say, I have come up before your lordship saying.
Show me an indication that the documents were not supplied, you have apprised to the court below.
That is annexure 4, my lords. Page 31.
No, this is the additional petition.
Sei gota kauchi petition.
That was not considered, otherwise there is arguments.
Because that was not considered and charge was framed, I came up before your lordship.
Charge was framed on the basis of the materials produced by the prosecution. There the accused has no right to produce even a single shred of paper.
ଆମେ କଣ କହୁଛୁ ଆମେ produce କରୁଛୁ ବୋଲି ଆମେ ତ କହୁଛୁ ଏ ଫାଇଲ ଗୁଡାକ produce କର କାରଣ
because the rejection of discharge application or framing of charge in one and same process modes.
That is why I placed paragraph.
But that was not the ground for discharge.
No, I did not ask for discharge.
You say in the absence of this document, it is very difficult for you to defend yourself.
Yes.
That's what you are saying.
I said.
In this revision.
Yes. What I said in this revision is.
You should have moved this application before trial court instead of moving.
Yes. And order should have been challenged.
Lord, the application of mine is pending at annexure 4. That was not considered by the trial court and the trial.
This application was moved before trial court.
Yes.
And yes, let us see. This application was moved on
2015
and the charge framed on?
Charge was framed in 2022, Millers.
Okay.
Right.
The petitioner is challenging the order dated 7/9/2022 passed by the Special Judge Vigilance Bhubaneswar in TR case number 33 of 2010, whereby charges against him is framed for offence under section 7. Okay. You page review. Right. Mr. Ponda, land counsel for the petitioner submits. Mr. Ponda, counsel for the petitioner submits that the petitioner had moved an application on 26/2/2015, seeking certain documents, seeking certain documents. And has urged before the trial court that in the absence of those documents, it is difficult for him to defend. Instead of deciding the application, the trial court went on to frame the charges. In view of the fact that the document sought by him was not supplied to him, he could not properly defend himself even at the stage of framing of charges. Mr. Das, land counsel for the vigilance, submits that in the absence of any
the charge has been framed on the basis of the material produced by the prosecution.
In the absence of any stay order, the trial has already proceeded and evidence is
at the fag end of the trial.
Evidence has already been prosecution evidence has already been completed.
This pending statement of accused
And,
being
the matter is pending at the stage of recording of statement of accused under section 313 CRP. Mr. Ponda, counsel for the petitioner, this application is pending.
Yes.
Submits that even today the application the trial court has not decided the said application. Therefore, seeks indulgence of this court with the direction to dispose of the said application in accordance with the law.
In accordance with the
In accordance with the law. Since the application indeed is pending before the court, it is.
Let's do it.
And the petitioner being an accused facing the trial has indefeasible right to defend himself in the case. So therefore, the trial court should do well to see that the application is disposed of
In accordance with law.
in accordance with the law at the stage of
Before completion of the evidence.
at the stage of
Before proceeding with recording of accused.
before proceeding to record the statement of the accused under section 336. This application is pending. Let them discuss with this observation. The petition.
Urgent copy.
Yes.
Item 13.
Then 13, I have filed an IA for appropriate orders, my lords.
What happened there? You were saying something, some prejudice, something.
Now,
Which part?
my lords, under the Special Courts Act, proceedings for confiscation are required to be disposed of within 6 months of the delinquent's filing show cause. Now, this proceeding was continuing. Now, I came up before your lordship against an order of that authorized officer refusing to release those shares which were seized by them in course of the investigation, my lords. My prayer was specific that I may be that the shares may be released for trading. I will trade those shares. I'll deposit the amount in the court. Now, my learned friend appearing for the vigilance said that the proceedings are at a fag end and the IO is to be examined. And accordingly, the matter was adjourned awaiting the examination of IO to be completed. The IO is being now examined from the 10th onwards continuously. Even today, my lords, his examination in chief is going on. But because of the order of
Then
your lords,
you are agreed by the speedy disposal of.
no, I am not agreed by that. I am not agreed. Personally, I am not agreed. I am aggrieved by the observation in this order sheet, my lords, that the authorized officer shall do well to see that the evidence of the IO is
recorded
without adjourning the matter anymore. It was not my prayer at all.
No, I am not saying you are
Exact,
but that as it may. It is onto the court.
Now, my lords, it is being projected there that the petitioner who has obtained this order.
What can I do if
Well,
I see the order is very clear. Your submission is recorded at the top, saying that despite the fact that the IO was summoned, IO is not coming forth.
I am explaining. My lords, when my learned friend said that the trial is at a fag end, my submission was that it is continuing since 2023 for examination of the IO. That is what I said.
So how would I change this order? In what manner? You suggest me so that I can change it.
My lords,
The last part, para 4 is the court's.
My only submission now is that your lordship may on merits dispose of my application. Your lordship may say whether my petition is entitled to be considered in my favor or to be rejected and let it be disposed. What has happened has happened. I am in no way, lords, I cannot improve on it.
Yes.
They have pointed out from the order that further there is nothing in the petition to substantiate the matter. That happened in this case, I will be examining shortly. So it was in the year of 2023 and he submitted that since 2023 IO is not being examined and your lordship is directed that it was my submission that IO is going to be examined on 10th. And your lordships passed that order basing on their statement. Now they are saying
More statement, more seat athila. I am agota katha kouch.
Your statement is not recorded.
No, I am making another submission. This is a confiscation proceeding under the Special Courts Act. It is dependent upon what? Upon the DA proceeding before the special judge. In the special judge, out of 75 witnesses, 7 witnesses only have been examined. The rest of the witnesses will be examined. Thereafter, the IO will be examined, cross-examined, and then my lords, suppose I am found not guilty, my lords, Even if the authorized officer confiscates my property, at that stage of time, 20 years later, the order is bound to be removed. The other aspect my lords may consider. Now, with so many prosecution witnesses having not been examined, what effective cross-examination of the IO can I do before the authorized officer?
Then I'll expedite that also.
No, I don't want an experience. That is not before your lordship. I'm happy that way, my lords. It's not before your lordship. But my submission.
Yes.
No. It is not that, my lords. My submission is that I come for a particular relief, my lords. Either your lordship grants that relief, rejects it. I have got nothing to say. My lords, these observations create difficulty.
Then, okay, where is the application? Where is the application? The application. I'll fix it for hearing. What is that application? Application? Which application you mean? Now, today you mean?
Well, that higher, my lords, your lordship may not pass any orders. I am not pressing that.
No, I'll record this and I'll say that the paragraph she misunderstanding, the court is misunderstanding.
Any date.
Any date you give. I am not bothered what is happening. I'll dispose it up. Irrespective of whatever is
Yes.
here. Give a date. Convenient date to give. 6 August. 9. Mr. Panda, counsel for the petitioner submits that irrespective of the proceeding, which is ongoing proceeding before the confiscation officer, he seeks, he requests this court to dispose of the present matter on its own merit, on merit. Since the matter is ready for final disposal, let it be listed on 6th of August for final disposal without waiting for the outcome of the proceeding before the confiscation. That will clarify. Yes.
Item 16.
Yes.
18, no? 16, 18.
Last time.
18,
If your lordship permits, my lord. Item 16, my lord, this is a case where, my lord, 3 revision petitions. One account officers, another exit engineer, and the contractors. Tagged belongs to them, lords. If my lord senior is ready, it can open, but I'm afraid may not get time. This is also another peculiarities in this case, my lord. A revision, the application for a discharge application was earlier filed, my lords. Then that was rejected and court held that charge should be framed. Thereafter, another application was filed for reconsideration of that particular order rejecting this application. On consideration of that application to reconsider, the impugned order has, in this particular case, has come up, lords. And 3 set of lawyers are there, including me, and we are ready, but I'm afraid may not get time. So if my lord senior is ready, you can open up the case.
No, we will not go piecemeal method. If you are ready, we will proceed. Otherwise, once I start reading, otherwise this hearing will go waste.
Correct, my lord. But why say so?
I just forgot it.
Already 2 cases are hanging, my lord. Matters. But I will be answering all those things in the Monday.
These are against the discharge.
Yes.
Discharge, but I will not open that, but discharge application rejected earlier. Thereafter, application was filed for reconsideration. Reconsideration application rejected, challenging that thing, revision.
Good time. My case relates to a specific point of law as well as merits. If I succeed on the point of law, my question of going to the merits may not arise.
What is the precise question of law?
The point of law involved herein is that the petitioner was prosecuted 4 years after his retirement. And the pension rules specifically mentions that if criminal prosecution is not instituted
Within
against the public servant within 4 years of his retirement.
Parametric rule is everywhere.
Yes, Lordship. And this is the promise given by the state itself. And how can the state prosecute? This is a part of the service rule. And this is the promise given by the state. And how can the same state prosecute me in violation of Section 115 of the Evidence
You
Act?
can't do that.
Principle of extra.
This point, my lords, I raised before Justice.
And there is a reported judgment recent.
Yes, there is also a judgment of this honorable
No,
court.
I also, I
Yes.
paid one of the matters. Justice Rastogi's a judicial officer, district judge of this court. I was appearing for this High Court, reported judgment. There also this exact similar situation.
Yes.
And my lord, this honorable court
Beyond
also.
that period, the
4
rule
years.
provides that you can't prosecute
4
beyond
years.
that period. A charge sheet was given.
But taking into
That's
consideration
it.
that, no,
That
my
is-
lord, my lord senior's entire case hinges on that particular point of
No,
proceedings, criminal proceeding, that includes criminal proceeding.
On
Well,
merit
well,
also
well,
I have a good
Justice-
case. Merit
will
leave
take time.
aside.
If
Justice
this point
Pujari-
of law
Justice
is there,
Pujari, Honorable Justice Pujari, my lords, I was the state counsel, Mr. Mr. Vishnu Pradhan was the petition counsel. The same question was raised, and they relied on another judgment of Justice Justice D. Das, my lords. That the same that proceeding includes criminal proceeding also. I'll just come back to
the
lordship.
rule you can't proceed.
I'll
The
just,
rule you can't proceed.
it requires, my lord, it requires consultation. I'll come back to it. But there are two judgments.
Then you confine your argument only on the question of law. They are covered by the judgment.
No, but,
And if they succeed in the question of law on factual aspect.
but again, my lord, that the revisional jurisdiction stares at me because they are challenged at particular orders. And my lord, this is a question which I have been prayed for, not
You
pleaded,
have
my
to
lords.
raise this point before the trial court.
No, how can they?
They will not.
In fact, their application for discharge was rejected. They filed an application on
In the
13.
discharge application, whether you taken this point also.
No.
I
I verified, lords.
I cannot say, but on the
The
point of
question of law can be taken up. in
question
this
of
stage
law
also.
can be taken.
Taken out in the revision.
If the
period.
proceeding is not
Yes,
maintainable.
any jurisdiction. Question of law
At
can
any-
be
Can be quashed in the 482 application for 227.
It doesn't make any difference, sir, if the
Same thing was
proceeding is not maintainable.
diluting everything.
If the proceeding is not maintainable, then
Then
my raising, if a question of law is not taken at the stage of the trial court, does the law
that doesn't prevent.
prevent
no,
me
in
from
fact,
raising
you
it?
have got any unimpeachable document in your hand.
If at all
Is
the
there a
question of
question of
law
law in there?
on
That
fa-
can be raised in 482 or 226.
Not necessarily.
Not in the revision
also,
jurisdiction.
I can go
Also.
into if it is a question of law and a question of law supports the facts. On the basis of the facts, if this question of law arises, it can be dealt with at any stage.
Neither it was raised before the trial courts, nor it was pleaded in the revision case, my lord.
Lordship,
And on the air, it will be making
regards
commission
482,
and order will be passed.
as regards 482, the Honorable Apex Court has stated that filing of the application also is not required. The court can exercise its inherent jurisdictions once it is brought to the notice of the court in any appropriate proceeding.
Hey, where is the pleading? Where is the prayer? Hey, air is telling us who?
Yes.
प्रार्थना नहीं और जी दे.
Point of law करो प्रार्थना.
Point of law आएंगे route 226 से आसो तो point of law सब तक करिए हम.
This is 2014 matter.
Lordship.
And that the delay is, my lord. Lords, you can see the dates. But I'll just place 3 dates. My lord, they filed application on 13/11/2013 for discharge. That was rejected on 17/12/2013. Then they, and after rejecting the discharge application, trial court held that charge should be framed. Thereafter, they filed another application for reconsideration. Ajib, it's a reviewing the trial court without any review power. Reviewing the and the impugned order emanates on the in the guise of reviewing or reconsidering the earlier or rejection, and the impugned order emanates. And now in that particular case, revision also, without any prayer, without any pleadings, they kindly entertain another question of law.
Was there any stay?
That,
Yes, there is stay.
no, not said. They're only for adjournment, person.
Adjournment. But charges have not been framed as yet.
No, you have to argue. This is a very point we have to
Lordship.
decide. When do you want Mr. Das?
I would say so. It aji hobanti.
Upon Purant, this is 2014 matter. 4 matters are pending. 3 matters are pending. We can dispose it up. Unnecessary, they are burden.
Let's two partners. One is the MJQ. The another is that.
When do you want? Next week, I want that this matter should be out. This way or that way, whatever.
Both the partners and then both the weeks, my lords. Let's say take the third week, my lords. The 22 that MJQ is coming out to, 29 that roads buildings coming up. Then we can take up that one, no problem. I don't stand on the way.
You just see when we can.
8 August.
Monday, Tuesday.
8 August.
Can I start hearing?
No.
Then if you are not ready, please make unnecessary.
In fact, another set of lawyers, they requested me during launch hour that they have some predicaments, so they may not touch. In fact, Mr. Moond also requested me, Sangrav, I am held up in another matters if possible.
So
but he finished it and come back.
Take it up, take the consent of both the parties and we'll fix it.
But at the same time, I request my learned senior in fact to consider the matter. Forget about law, the basic common sense also. No amendments, no prayer, or neither raised in trial courts. First time coming up, and not in the revision petition also. And those things will be taken care of. We will take cognizance of all those matters in the air. I understand his difficulties. That question of law, I understand because I argued that matter because Justice Pujari, my lords, and Mr. Pradhan was a counsel. He relied on the judgment of Justice Bikanek. Bikanek said that proceeding include criminal proceeding, and that passed his judgment. That judgment was
You tell me one thing: if he can successfully point out that legally the proceeding is barred, the revisional court is barred to go into it. But in the absence of pleading.
But without particular.
What pleading is required in a criminal jurisdiction?
Well, in a revision jurisdiction, my lords, I don't.
No pleading.
No.
We are not going to decide a criminal matter on the basis of pleading.
My point is that revisional point is that if a question of law or a fact raised with the trial courts, that was not
justified from the available record. If he satisfied,
that was not considered. That was not raised before the trial courts. Well, how that will be raised?
Otherwise also, in 2013 matter, are you suggesting that they should go back to the trial court and run around for another 10 years? 10 years have already passed.
No, that is different.
And we are not able to decide
for that reason, that side of the coin, I agree with him. Their predicament, but they cannot expect us to start to create a new law for them.
By you prepare a written note on the question, supply the copy. And on the basis of written note, I'll decide.
And on that point, let my learned senior enlighten us that if in a particular point not raised before the trial court, not prayed for with the trial court, and not raised in the revision petition, and not raised, and the midst of the revision petition, and you raise some question of law, which doesn't happen.
I'll settle that.
Lordship.
Lordship. Rule.
7(2)(c).
That's why, my lord, that is Supreme Court said that if there is any unimpeachable character, any important question of law is there, that can be placed into service in your benefit if you approach the 482 application, proceeding on the 482 or 226.
7(2)(c). Rule 7(2)(c).
Mr. Moond and Council, present petition is arising out of the order dated 8/1/2020 to 2014 passed by the Special Judge Vigilance Baleshwar in TR case number 298 of 2007, whereby the application moved by the petitioner for discharge has been rejected.
No,
Huh?
their application, my lord, for discharge was rejected by order dated 17/12/2013. Thereafter, they filed an application for reconsideration of this order dated
No,
17.
not me.
The prayer for the petitioner for discharge.
No, prayer for
has been rejected.
17
That is prayer,
to
ultimately
17.
the prayer rejected. The matter is pending since 2014. 2014, and both Mr. Das and Mr. Mund conjointly submit that the charges has not yet been framed. Charges has not yet been framed. Mr. Moon points out that under the Orissa pension rule, under the
7 to C, Lordship.
7
7 within bracket 2 within bracket 1.
Under rule 7 bracket 2C. 2C of Orissa pension rule, the prosecution could not have initiated the state could not have initiated the proceeding against the present petitioner after 4 years of his retirement. He insists that this is a question of law on the basis of which the entire prosecution is barred. Mr. Das, learned counsel for the
my submission is
submits that this point is neither urged before the trial court, even nor before this court in the revision petition. Therefore, the petitioner should not get audience insofar as this issue is concerned.
And secondly, my second submission is that their application for discharge was rejected.
That is again,
And
I'm saying something else. I'm not.
My lord, rejected. Thereafter, they again reviewed the matter. Is it permissible?
And he also submits that their initial application for discharge
Was rejected.
having been rejected.
And High Court held that room for framing of charge
A second application was also not
for reconsideration.
for reconsideration.
That amounts to reviewing it. And the criminal court has no power to review.
At the outset, in the time of the prima facie view, that if there is a question of law raised by the parties, even without pleading, the same could be decided at this stage. Having said that, the parties are directed to place on record a written submission pointing out the question of law and judgments, supporting judgments, in that regard. Leave the matter on
12,000. 12,000.
Lordship, I have a
and
request to
2 weeks
Lordship.
time, 1 week time is granted to both the parties to exchange the written submission.
Written note of submission. I
written
have
note of submission along with the written report judgment.
I have a request, Lordship. Since the matter relates to the date of retirement, my learned friend should be directed to verify the date of retirement.
You tell me, I'll go by that retirement.
I have mentioned in my application.
And you are going to give written submission
Lordship,
prior to,
Lordship.
and he'll, while responding to written submission, he'll get the instruction.
Lordship.
Let's say fix it on second week. 2nd of August. Timeline.
And then you give a exhaustive written submission along with judgment, and within 1 week, and once you give advance copy, they'll respond.
Lordship.
Yes, we'll decide it.
Item 18. It's a 2 years conviction. Under section 498 34 IPC. The petitioner is the husband. Here is the case, initially affair has been lodged as against the petitioner and his mother for the offense under section 498 306 34 IPC 4 DPR.
Mother died.
Mother, convicted, since rising of the court. Convicted. Here before lordships one petitioner, it's a concurrent finding. I am arrested on 18/7/2009 and released on bail by this honorable court 9/9/2009. Right, BLAPL number 12462.
So
Near about 3 months.
3 months.
3 months inside the custody. And here is the case,
what was the sentence?
Sentence 2 years.
And after trial, after trial stage ଥିବେ ନା ପୁଣି appeal stage ରେ
appeal stage ରେ previous spell ରେ continue କରିଥିଲେ
under trial how much? This is an appeal stage.
under trial my lord near about 3 months. Near about 3 months. After 13 years, my lord, there was a dispute and the wife, my lord, taken poison.
Right.
And only, my lord, the family members of the, my lord, the deceased family members, my lord, deposed that there was a, my lord, dispute between the husband and wife.
You convicted at 306 or 304?
No, lord, it's only 498. I am acquitted, my lord, 306.
Only 498 sentence is
there are one of the witness PW 8, 9, 10, 11, 15, my lord. They have categorically stated the treatment.
No, I'm not acquitting. Sentence.
Sentence may extend to 3 years, my lord. May extend to 3 years. May extend to 3 years. May extend.
And fine.
And also
you undergone 3 months.
Appeal stage रे previous वाले मुझे order sheet verify करथली. I verified the order sheet, my lord, before the, my lord, the in appeal, my lord, the previous spell से continue करिया पे आगे direction है चला. जहाँ मैं आगे देखुथली LCR टा verify करथली.
ताले appeal रे जाइनी. Yes, tell me.
And only, my lord, basing on
what
the
is his age now?
Yes, my lord, at the time of filing, my lord, 2014, 39 years. 15 ମାନେ ଆଉ
39, 49, 50. Government work, job, no.
Man, I am that interested in, my lord, I don't.
What do you say, Mr.
Extend to 3 years, you'll also may.
ଦିଟା ଛୁଆ ଅଛି ଗୋଟେ ଝିଅ ଗୋଟେ ପୁଅ
Sentence undergone.
You are taking care of them.
ଆଜ୍ଞା ସେଇଟା ବି ମୁଁ ଆଜ୍ଞା try to contact my trial court lawyer said that ମାନେ ସେ client ଆଉ ଦେଖା ଦଉନି କେବେ 2014 ପରଠୁ ବେଲ୍ ହେଲାଠୁ ଆଉ ଦେଖା ଦେଇନି
Undergone or few? Because my lord, the with regards to 490 it clear made out.
I have seen.
And often may extend
four DPX,
3 years,
four
my lord.
DPX, my lord, that at the time of charge sheet, my lord,
The children, what is the age of the children?
the my lord petitioner,
Children.
Children. বয়সটা স্যার
Just see, find out.
মাল
Marriage between them took place
after 13 years.
right.
After 13 years, my lord.
The son and the daughter. So, children must be grown up now.
My lord.
In the meantime.
Evidence, just see the evidence of the mother, son.
अच्छी evidence है ना again evidence है again
PW 10 and 11 तक PW 10 and 11
I got the mallet soft copy during lunch hour a hard copy again ମୁଁ କରିନି
Page 16. You know, 9, 10, 11, 15 have stated that they learned from the villages that the accused persons had assaulted the disease and also killed her by administering poison.
No, I am just
It's in that
looking at whether the children were examined.
only judgment ballot documents applied.
Just find out from.
My lord,
Yes, find out. I'll leave. Find out. This one he will tell from trial court record. Just find out.
My lord, I got the LCR, my lord, soft copy LCR, my lord. I will verify and
Next week. Next week.
Next week.
Yes.
26.
Yes.
May I please, Your Lordship? My lord, here the petitioner has been convicted for the offence under section 379 of IPC and has been sentenced to undergo arrest for 2 years, Your Lordship. Pursuant to Your Lordship's direction, I had already filed the written note of submission. And in fact, the learned courts below, before convicting the petitioner and the learned appellate court, before confirming the judgment, have not taken into consideration the material contradictions of the witnesses, which clearly states, my lord, PW5 is the informant who in his examination
Show
in
me
chief.
the written submission.
My lord, I had filed prior to launch, I had.
Give the records. Yes.
My lord, paragraph 3 of my written note, my lord, PW2 and 3, though they are the vital witness for the prosecution, but in their examination in chief, they stated that hearing Halla, they went to the spot and found 8 iron angles have been cut, 2 aripatis and 2 motorcycles were there, and further they found the accused persons and the villagers at the spot. But in their cross-examination, they have categorically stated that they have not seen who cut those iron angles and how they were cut. Data part, my lord, PW5, the informant in his examination in chief has stated that from the spot they could apprehend only one accused person, namely Premjit Singh alias Gajju. And thereafter the other accused persons came to the village by their motorcycle, and it symbolizes that the present petitioner was neither at the spot during the alleged time of occurrence, my lord. And PW1, my lord, who is a seizure witness, he has specifically stated that a Rajdut motorcycle, 2 aripatis, 8 number of iron angles were seized from the spot by the IO, that is PW7, but the IO in his examination in chief has stated that he seized 2 motorcycles, 8 numbers of iron angles and 2 aripatis from the accused persons and prepared the seizure list. Now, my lord, my humble submission is that the present petitioner, as per the case of the prosecution, he was not apprehended from the spot. He was neither at the spot nor, as per the statement of the PW7, the alleged incriminating materials were seized from his conscious possession, your lordship. And that apart, my lord, the IO in his cross-examination has clearly stated that PW5 was not the chowkidar of that particular spot at the relevant time, and there was no chowkidar appointed at irrigation guest house.
What is recovered from you?
My lord,
What is recovered from you?
my lord, the IO has stated that he seized the articles from the spot from the accused persons, but the statement of other witness narrates that I was not at the spot, my lord. The alleged articles were seized from the spot itself. That PW2 and 3 there speaks like this. The alleged articles were seized from the spot. And corroborating.
Mr. Raghuda, if everything is seized, where is the question of
What happened in this
spot?
case, my lord?
379, how?
There are, my lord, 3 accused persons, my lord.
No, 4.
4 accused, 1 accused apprehended, my lord. And 2 of them fled away from the spot, my lord. when the Pidol 5 in the informant and the other villagers, my lord, they cut out 1 and 6, my lord, they cut out that man, recover one Aripat and also the angles, my lord, iron angles, my lord. And thereafter, this petitioner and another co-accused came to that spot, my lord. Straight away, again came back there. The motorcycle of the which was used in the crime, my lord, that has been, my lord, seized, my lord, belongs to this petitioner. And one of the co-accused, my lord, he, while at the time of framing charge, he confessed his pleaded his guilty and also convicted. And this man, along with them, are there, my lord, Pidol 5, Pidol 7, category stated, and Pidol 1 and 6, my lord, seizure witness, they, my lord, prove the fact of seizure regarding motorcycle and other materials, my lord. So, my lord, the question of acquittal does not arise, my lord, this case, my lord. At best, your lordship, the conviction of 2 years, my lord, 379 and 34 IPC.
Undergone.
My lord, I have mentioned, my lord, in paragraph 8, I was taken to custody on 16/1/2004 and was released on bail on 19/1/2004, your lordship.
3 days.
3 days.
Only 3 days custody.
And also, my lord, in this case, my lord,
but PW 5, my lord, the informant, basing on whose information the prosecution case was launched, he claimed himself to be the watcher of that irrigation guest house, but it has been completely denied by the IO, my lord. IO, in his cross-examination, he has straightway.
that part has been clarified in the judgment, my
So
lord.
that is there, my lord.
On basis of basing upon his information, investigation by the carried, my lord. During investigation, certain things are found and charge sheet submitted. So the question is whether he is a watchman or the co-villain, that is not, my lord, the question. Any person can lodge.
Only 379.
379.
Only 379. 8 number of iron angles were caught.
What was the age at the time of?
My lord, by filing the present revision, he was 26 years in 2011. And
No. 26.
by filing of the revision in 2011, my lord. Next one.
2004, in the year 2004, you were 22 years. Okay. How in 2011 you are 26 years?
So judgment.
Huh?
And 2004.
See the impugn order. See the impugn order.
My lord.
Impugn order is in 2004. There it is written you are 22.
My lord.
And in 2011, you are 26 only.
Lordship, may I dispose of the matter?
1984, date of birth, year of birth.
My lord.
84.
84. By the time of judgment, he was 22 years.
4 years.
24
years. 26 years, 11.
40 years.
44. 54.
Until 11/26. 11/26.
No, from charge sheet I have seen it. He was, his date of year of birth is 84. 1984. No question of conviction, acquittal.
Lordship, में PO Lordship में consider.
चलो PO कर दो.
Sir also saying, sir.
लिख दो उसमें।
Item 30.
Sir is waiting.
My lord and friend is pressing hard to argue the case. Item 36.
All the best.
Huh?
I wish you all the best.
All the best. Nothing.
No, that is no coercive.
My lord and friend is pressing hard. My lord, I have heard in the first hour that it has been adjourned to next week and will be taken up in the mail list. But my lord and friend again opposed. It has.
I wish you good luck.
ठीक है. Well, here is a case. The appellant was placed under trial in the Court of Special Judge Vigilance, being charged under Section 7 and 13(1)(d) and reduced Section 13(2) of Prevention of Corruption Act 1988. The allegation as per the...
Such a big volume.
It's a big volume, and I will also give a memo of citations. It will again be bulky.
Eh? And citations you have given already.
No, citations, my lord, that is with regards to suspension of sentence, basing upon which interim order was passed, and my lord and friend has filed an application for vacation of that interim order, and it has been dismissed. Now, on merit, I have got other citations, which I will draw
What is your best point? You just
best
tell
point
one
is
so that
yes, I have prepared. I have also prepared my note of submission, taking the best point as the first point. That is, my lord, sanctioning authority who has accorded sanction has not been empowered under law to accord sanction because he is not my appointing authority. Number one. Number two, that sanctioning authority who has accorded sanction has not been examined during trial. This sanction order has been exhibited or has been proved or has been produced by investigating officer with objection. Question comes off, if the sanctioning authority has not been examined and the sanction order has been exhibited, what would be its effect? With objection, what would be its effect? My lord, beginning from 79 Supreme Court 677, that is one of the off-court decision on the point of sanction, that according sanction is not an empty formality. It's a sacrosanct act. Because a public servant is going to be sued or prosecuted basing upon that sanction, that is the first.
Let us come to the trial court.
Yes.
Where it deals with the sanction.
My lord. This court has also dealt, my lord, with regards to non-examination of this sanctioning authority and its effect. But if my lord will see the trial court judgment, trial court, my lord, as it happens nowadays with in trial courts, my lord may see, say, my lord, internal page judgment paragraph, page 13. He has taken note of all the decisions which I have cited and just left it.
Where is that?
My lord may see.
31.
Page 13. Let me see. Say around 13 decisions has been taken note of, and this vigilance has cited 14 decisions and proceeded with the case on its own way. What I want to say, my lord, whatever may be the line of judgment or line of analysis by the law and trial court, my lord may see the evidence of PW6. Evidence of PW6 Well, before going to that also, to prove a case, as has been decided by the Honorable Apex Court till 2023, my lord, Neeraj Datta's case, two things are important, my lord. One is offer, and the other is acceptance. Prosecution is to prove both the things beyond all reasonable doubt. Then the burden shifts to the accused, or the presumption lies on section 20 of the Act. Here, my lord will see PW1 is the person who can be termed to be accompanying witness or overhearing witness. The duty of overhearing witness is when the transaction takes place, when the offer made by the complainant and the accused accepted the same, he is to hear and he is to give a signal to the other end, the trap laying officer or the other officers, those who will be waiting outside, to come to the spot to seize this, that. Here, my lord will see if without considering anything, he says, I was waiting outside. 5, it is alleged, the complainant PW3 went to the house of the accused with his father. There, the accused was present in his residence and sitting in the drawing room. He was AAO during that way, assistant agricultural officer. He said, I was waiting outside. At that time, 5 minutes thereafter, the complainant came out and gave a signal, and by rubbing his head, and I intimated accordingly to the trap laying officer. So it is admitted that he has not heard anything. So PW3 says, I went inside the room. Accused was talking something over mobile phone in his left hand, and I handed over the money to him, and he kept it in his right hand. And I came out, I signaled to the overhearing witness in its turn intimated the other officials, trap laying officer PW5, 6, they came, seized, and other things followed. This PW3 complainant, during inquiry, departmental inquiry has also been conducted in the present case, has candidly admitted that I have not stated before the investigating officer about the alleged demand of the accused. Question comes up. These are the all facts which I will draw my lord's attention from the evidence. Yes. I think that if there will be any factual mistake, then my lord will point it out. PW5, who is the trap laying officer, TLO, he has categorically stated in his evidence that before the trap, alleged trap, that is on 23/12/2010, the DAO, divisional officer, my lord, who has not been examined in the case, I don't know why he has been withheld from the prosecution box. He had completed all the work and it was submitted before the bank on 21/12/2010. If the work has been completed on 21/12/2010, there was no necessity of demanding money and to be paid on 23/12. Bereft of it, my lord, I want to draw my lord's attention. It's not the present appellant was there on being, my lord, on a transit job, so to say. He was not entrusted with that work. They have seized the document, they have seized the letter, where it has been categorically mentioned that it is not the work of the present appellant to deal with this type of things. If my work or my work chart has not supposed to, or it's not within my scope to do a particular thing, why I will accept it, why I will accept the money, which is not been, for which I am not entitled. I cannot do anything for him. The reasons for launching a prosecution is some staffs, those who are not, because I do not belong to that particular office, because I have come there as an interim adjustment. Some staffs were not pulling on well, and they have created this thing. That is the case in 313 and also a defense case. Law is very clear. Mere acceptance of money, divorce of anything,
Without demand.
without demand, divorce of anything, that language has been used by the apex court, will not attract the ingredients of Section 7 of the PC Act. Here,
What happened to your departmental proceeding?
departmental proceeding, my lord can say better. Departmental proceeding, I think I have been exonerated. My lord. My lord, evidence of PW1 is very clear to the effect that he has not seen the transaction. He has just relayed it.
PW1 and PW3.
PW1 is overhearing.
PW3
Is the complainant.
Complainant who said that when I went inside, he was talking.
My lord, he says, I have received I have handed over the money, and my lord, after that, the raiding party, they came, they turned into the right hand of the mobile, and so everything, my lord, he has categorically stated. What I want to say, my lord, let me see evidence of PW5. Officer who was with a trap laying officer, TLO. Paragraph 7.
PW3 evidence is very important.
Married.
When the accused was busy in talking about his phone, the complainant pushed some notes.
Fact that, my lord,
Went away from the
if I can do some work, it is accepted that yes, I have received money. If the work is beyond my scope, beyond my territory.
It has already been done by.
Yes, that has been decided by the apex court.
DAO.
I have brought decisions in that respect. Well, beforehand, I just want to give a brief picture of the case before going in detail. Paragraph 7, my lord, of PW5. I have not verified any document relating to the allegation in the affair. I had made pre-trial discussion with the district agricultural officer. Very peculiarity is DAO has not been examined. Prosecution is not bound to examine, my lord, all the witnesses in the charge sheet. But they should examine the witnesses whose examination would have unfolded the narratives. That is the language used by the apex court time and again in many cases. Because here I'm coming, why I'm saying DAO, sanctioning authority and bank authorities, their examination was important. I have not verified any document relating to the allegations in the affair. I made pre-trial discussion with the district agriculture officer who intimated me that the accused assistant agricultural engineer is to prepare the estimate, etc. for dairy farm. But he had not disclosed the memo number or the details in which the duty of assistant agricultural engineer is assigned. I cannot say the name of the DAO. He has examined DAO, but he cannot say. I have not reflected in any of my document. It is not a fact that the assistant agricultural engineer is not authorized to prepare the estimate and project report of a dairy farm. As per the letter of the Director Agriculture and Food Production Orissa Bhubaneswar, AE is not authorized to prepare plan, estimate and project report of a dairy farm. I cannot say if preparation of plan, estimate and project report of a dairy farm are being prepared by veterinary department as it relates to animal and husbandry department. So, if he has received a letter in that respect,
There was no occasion for him to pay money.
My lord, paragraph 11, my lord, we see. It is a fact that I have not mentioned in the detection report and my 161 CRPC statement that the accused demanded bribe and accepted from the complainant. The trap laying officer himself has candidly admitted, and during inquiry, the complainant has also admitted that he has not demanded anything. Mere recovery of tainted money, divorce of any fact, during remand, my lord, that clearly law clearly says that it, my lord.
Yes, Mrs. Das, how will you get over all these things?
Case is very simple.
You want to make it simple now?
Yes, madam, I am submitting your lordship will be.
See, sanction insofar as sanction part is concerned,
Yes,
the trial court, trial court has not dealt with it at all.
Yes, the trial court in page, your lordship may kindly turn to page 42, running page 42.
Yes, I am there. 42.
Sixth line. Regarding deposition of PW6.
40.
Running page 42, typed page 32.
That type is
32, 32.
32.
Sixth line from the top.
Exhibit 13.
He has deposed on that on the same day. Your lordship got it, seventh line.
Read this from the top.
From the top, duty distribution charge of Probation Chandra Das, AAE, Office of the DA of Barampur, from Assistant Agricultural Engineer Ganjam,
1 minute.
Rangei Lunda.
He has deposed on that day.
He has deposed that on the same day. He held pre-sanction discussion with Dhubai Charan Sahu, officer on special duty GA department, Bhubaneswar, against Prabir Chandra Das, AAE. He then produced the FIR preparation report, detection report, seizure list, and other connected documents for perusal for sanction order. And on 21/5/2012, he received sanction order against Prabir Chandra Das and marked the sanction order as Exhibit 15 along with the forwarding letter of sanction order as Exhibit 15/1 in evidence. So I will cite this that when a public document is marked through a public witness, it can be treated that no sanctioning authority is not bound to be examined in each and every case.
Was he competent?
Yes, the office, the IO is competent to mark the...
No. The sanctioning authority was competent to give sanction.
Give sanction. He is the authority, Dhubai Charan Sahu. He was the... Your lordship may kindly have a glance to the evidence of PW6.
He was the special...
He was the special secretary in the GA department. GA department is above all. General Administration Department controls entire departments. My lord might be knowing.
Right.
So your lordship may kindly have a glance to
okay, this is what? Next, how will you get over the demand part?
Demand part. Your lordship may kindly have a glance to, first I will bring it to the notice of this FIR. Your lordship may kindly have a glance to the FIR. FIR is at page 52 towards bottom.
52.
Towards bottom. It is in Oriya.
52 of what?
DAO officer assistant agricultural.
52 of what you are reading?
58 of the paper book.
Paper book. Where is paper book? Give me. Where from he got it?
I received on Ponder sir.
He got the paper book.
Yes, I have been supplied with by the department.
By the department, I'm more delivery.
No. By section, criminal section. Your lordship may kindly have a glance to the notice noting. Cause list noting. Your lordship may kindly have a glance. Last. Cause list item number 36.
Get a copy. Give it to him also.
Your lordship may kindly have a glance to the cause list.
I'm sorry.
Cause list in the end.
ଆମ କପି ତ ଥିବ ନା?
Paper book and memo of
got it.
citations.
ନାଇଁ
Paper book, memo of citations.
15/7 ମାନେ ତ କାଲି ପରଦିନ ପାଇଛ ଆଉ 15/7 ମାନେ କେବେ?
ମତେ ତ ଜାଣ ସେକ୍ସନ ବାଲା କ୍ରିମିନାଲ ସେକ୍ସନ ବାଲା ବୋଲେ
ଆରେ ପେପର ବୁକ୍ ଆସିଛି ନାଇଁ ତ ହେଇନି ମୁଁ ତ ଭାବିଛି ପେପର ବୁକ୍
Keep it parted and give a copy. Parted next week.
only I am bringing to the demand part.
ହଁ ଦେଖିବା
Parted, huh? Parted. Yes. Yes.
ପେପର ବୁକ୍ ଟା ସାମନେ
Small matter means
already the start the period of
undergone.
Item 30.
I have made one written note of submission.
You give it give it to him also.
Yes.
Parted on that day you give.
On that day.
Yes.
well interim order to continue till that
That's all. 32.
On which day it will be taken up?
He will adjust and give you. He'll call you and go. 32. 31.
I'm placing 30, Lordship. 30. 30.
30.
Lordship.
What is this matter about?
Material, Lordship,
Can it be over within 5 minutes?
yes, it can be considered under P Act also. Because the conviction is 1 year for 353, 1 year for 506, and 3 months for 294 of IPC, Lordship. And materials are there. In fact, the allegation is that
Undergone?
period undergone is exactly, I was going to the LCR only in the soft copy. There, as I found, it is within a month only. It's not around month also. Because soon after he was remanded, thereafter sent into custody in the next state. Thereafter 3
What
days.
is the substantive sentence?
2 years and 3 months. 2 years is for 353, 2 years for 506, and 3 months is for 294. So in 294, he has been given 3 months only. And in the 353, he has been convicted for 1 year, RI. And 506 is also RI for 1 year.
Keep it next week. We will see.
Lordship.
Next week.
Grateful.
grateful
Hmm?